Lordship, in this interlocutory application has been filed to this interlocutory application has been filed to delay the condonation.
How much day?
1220 days, Your Lordship.
Service complete?
Not yet, Your Lordship.
Not complete.
Not complete. May I
await service.
Reason have been, Your Lordship.
Await service. List again after 2 weeks on a date to be fixed by the registry.
Obliged.
May I please, Your Lordship? Lordship, I am making this prayer on behalf of MSS Roy, Your Lordship, due to some medical emergency.
You are for the
appellant, Your Lordship, insurance company.
What is the why is Mrs. Somaria not before this court today?
Lordship, she is having some medical emergency. She is under treatment.
All right. Your Miss
FN Jaman.
MSFN Jaman, learned counsel for the appellant, seeks 2 weeks accommodation in the matter as the leading counsel is undergoing medical treatment.
Yes, Lordship.
Prayer is not prayer is allowed. List of 2 weeks on date. On 2 weeks is all right.
Yes, Lordship. Obliged, Your Lordship.
On such and such date. None appears for the appellant when the matter is called. Stop. List again on Fridays, give Friday's date, on such and such date, with remark within quotes for dismissal in the order column. Friday is a holiday, Monday. Monday, I think, is also a holiday, no? Give Tuesday date. Yes.
Wait, please, Lordship. Lordship, the engaged counsel couldn't reach the court due to the waterlogging, Lordship.
Waterlogging?
Yes, Lordship.
Where was waterlogging?
Sir, this is Garu.
I have also come from an area which generally is always flooded. Mr. Fukan and Mr. Sharma sitting behind will know. They also are from that locality. There was no water today.
It's a remote area, Lordship. It's a Garugoli, Lordship.
It's a 2016 matter.
Yes, Lordship.
Anyway, your name?
PJ Das on behalf of M. Chaudhary.
M. Chaudhary. Yes. Any
Lordship,
objection?
Lordship may fix another day.
When do you want it? Thursday or next Tuesday?
Lordship. Next Tuesday, Lordship.
Your name?
PJ Das.
Mr. PJ Das, learned counsel for the respondent, submits that the leading counsel, Mr.
M. Chaudhary.
M. Chaudhary, could not reach the court due to the waterlogging problem in his locality for the ongoing due to the ongoing rain, and seeks accommodation in the matter. Prayer is not opposed. List on such and such date.
Obliged.
Thank you.
Time for the respondent.
Yes, but petitioner not there. These are old matters. If counsels are not there, very difficult.
Last question also they did appear.
They are not there. Then I'll dismiss it.
Yes, order is there.
None appears for the appellant on call. Stop. Mr.
BP Sinha.
BP Sinha, learned counsel for respondent numbers 1 to 5 is present. Stop. It appears that on 29/7/2024, when the matter was last called, there was no representation on behalf of the appellant. Stop. As such, stop. Don't say yes, sir. It appears that this matter was fixed today, I-28/2024 for hearing. Stop. Since today, when the matter was fixed for hearing, neither the appellant nor his counsel has entered appearance when the matter is called, comma, the appeal stands dismissed for non-prosecution. Yes, where is your counterpart? Substantial question there or not there?
There is a substantial question, sir.
There is.
Yes.
You being very fair. What is the substantial question involved in this appeal?
Lordship, the issue number 2 and 3.
Which is the order by which the questions were formulated?
Order?
Lordship, I'm trying to call Mr. M.J. Kadir, who is to appear in this matter, Your Lordship. I'm trying to call
Lordship may fix another
another
date,
date, Your Lordship. I'm trying to call him, Your Lordship, but he's not receiving.
None appears for the appellant when the matter is called. Stop. MS
FN Jaman.
FN Jaman, Learned Counsel for respondent number. For respondent is present. List this appeal on such and such date.
Okay.
Again on such and such date.
Oblige.
Item 15 may also go. Item number 15 also go.
Same. You are appearing?
Yes, Your Lordship.
All right. 14, 15.
Respondent number 1. Oblige, Your Lordship.
My lord, after demise of Mr. B. Kulita, my lord, senior advocate, the party wants to engage some other advocate. My lord. It was led by Mr. B. Kulita, senior advocate. My lord, what do you think?
This was led by?
But this case was led by Mr. B. Kulita, my lord. But he is no more, my lord. The party wants to engage some other advocates. My lord. After 4 weeks, my lord.
Your name?
A. Khonikar.
S. Khanikar.
A. Khonikar.
A. Mr. A. Khanikar, Learned Counsel for the appellant submits that in view of the demise of the leading counsel, Mr. B. Kalita, comma, the appellant he has received instructions that the appellant desires to engage a new set of counsel and accordingly seeks accommodation in the matter. They are allowed list
After 3 weeks.
list after 2 weeks on a date to be fixed by the registry. Needless to clarify that if on the next date of listing alternative arrangement is not made, the appeal shall be taken up for merit or on its own merit.
This lord.
Can you take after some time, madam? Respondent also not there.
But you be there. Don't disappear.
Please, Lordship. Lordship, I am for the appellant. And Lordship, I am appearing on behalf of Mr. L.R. Lordship.
Mr.
L.R. Lordship. Lordship, actually, the connected matter is wrongly typed as 448 of 2017, Lordship. Whereas the actual connected matter is 488 of 2017, Lordship.
The connected matter kuntu aise rupa? Number to what? Ki aise 448 aise. 448 aise. I don't know how. Then I will ask direct relisting.
In 448, we have the appellant.
Yes, but 448 is not connected to this.
Lord, I just can't say that.
It appears that the instant appeal has been listed along with MAC appeal 448 of 2017 instead of MAC appeal 488 of 2017. Stop. Registry to list the appeal along with MAC appeal 488 of 2017. I'm not passing any order in your case.
Well,
Lordship,
Because this has been
maybe
roughly
fix on next.
List the matter after 1 week on a day. Appeal.
oh no, not in this case.
In your case, I'm not passing any order. That
Well-
has wrongly come up.
In 708.
In that case, my lord, if your lordship like to take it,
Now 448 to some.
to me, assign. She has some problem, my lord.
It appears that this matter has been wrongly listed along with MAC appeal 708 of 2018. Stop. Let registry detect this appeal and list it on next week or after 1 week.
After 2 weeks.
After 2 weeks on a date to be fixed by the registry.
Obliged.
Much obliged.
May it please this, my lord.
Your lordship, kindly take the matter after some time.
Why? What is this matter, Mr. Iqbal?
My lord, landlord-tenant dispute, my lord. I'm the unfortunate tenant, my lord. I lost
Lordship,
in
my
both the
senior is
courts.
coming.
Let
his
him come.
office.
Let him start. Who's your senior?
Our Ali.
You inform that I have started the hearing. If I keep adjourning all the matters, there'll be nothing remain for me to do.
Yes, lordship.
So, yes, Mr. Iqbal.
My lord, the respondent
This is what? This is a revision under 115 or 227?
115.
115. Yes.
Under Assam Urban Areas Rent Control Act, my lord.
Assam.
Urban Areas Rent Control Act 1972, my lord.
Assam Urban
Areas Rent Control Act 1972,
Rent Control Act
my lord.
1972.
72.
Huh? Yes, please.
My lord, the respondent as plaintiff my lord, instituted suit, title suit 105 of 2013 for eviction of the tenant, that is the present petitioner, on the ground of,
You are the tenant.
I'm the tenant, on two grounds, my lord. On the ground of defaulter,
Yes.
that I have not paid the rent since the month of August 2012. And on the ground of bona fide requirement, that the suit premises is required bona fide to start a business for him as well as for his family members.
Yes.
So on both the grounds, my lord, the learned trial court decreed the suit. Being aggrieved, my lord, I assailed the order, judgment and decree, and I preferred an appeal. On the appeal also, my lord,
What is the jurisdictional error, Mr. Iqbal?
jurisdictional error is, my lord, my first point is, my lord, under order 41, rule 31, my lord.
Yes.
On two grounds, my lord, I had preferred
Order
that
41 rule?
31.
Yes.
Not all the issues were discussed by the appellate court. But I had preferred the appeal on the ground that I am not the defaulter and there is no bona fide requirement.
You have not filed an appeal. You filed a revision petition now.
First appeal, my lord.
Okay, you have first.
first appeal.
This revision is against which
Against the
order?
dismissal of my first appeal, my lord. Title appeal. So my lord, my title appeal I had filed on the ground that I am not a defaulter and there is no bona fide requirement. So on the ground of bona fide requirement, my lord, there is absolutely no discussion, my lord. That issue was not even taken up, my lord.
So one of your argument is that the point determined is not discussed
Discussed.
by the appellate.
Appellate court. Secondly, my lord, on the ground of defaulter,
Yes.
it is incumbent upon the courts below, my lord, to help me a defaulter. If a tenant is held to be a defaulter, then the due date, my lord. From when was the due date and when he defaulted, that has to be stated in the judgment, my lord. When is the due date? That is very important, my lord. There are a number of judgments, my lord. But the learned trial court as well as the first appellate court has not at all discussed that when was the due date, when the rent became due, my lord.
Yes.
So if, my lord, the learned trial court as well as the appellate court has not given a finding as to when the rent has become due, my lord, then I cannot be held as a defaulter. So on these two grounds, plus, my lord, on the ground of defaulter, the learned trial court held subsequent events, my lord, after the institution of the suit that I had defaulted in payment of rent for a number of months. But that is subsequent to the filing of the suit.
The evidence do not indicate the due date.
Evidence also, my lord, do not indicate, because, my lord, if my lord comes to the tenancy agreement at page number 22,
Page number?
22, It's there in the, my lord. It's there in the revision petition.
Page number?
22.
Yes, this is the tenancy agreement.
This is the tenancy agreement, my lord.
Yes.
I'll just come to the point. my lord. So here also, if my lord comes, then the first point at page number 23, the tenancy was in force for 3 years from 2009. But the due date when it is to be paid
Yes.
at page number 24, clause number 3, my lord, that the second party have to pay the above mentioned.
Within the first week of each and every completed month as per English.
So, my lord, for each and every month, whether it is the subsequent month or whether I have to pay on that very month, that is not clear, my lord.
Mr. Iqbal, now you can't take advantage of this situation that it is not clear.
My lord, but the learned trial court, appellate court has to say something, my lord.
I
Has
will
to
see
say.
what the appellate court has
My lord,
said,
my lord.
but the condition is there and you are a tenant.
My lord.
How can you not pay the rent?
I have, my lord, they have stated that I have defaulted since some August 12th. My contention is that, my lord, he used to give me his hand over his electricity bills.
Agreements, because you see agreements are made between two parties and the parties understand the best. So your conduct will show in the previous months as what you have understood and how you were making the payments and which they were accepting. So does the evidence show that or not? That in the previous years, this agreement was entered in 2009, September 2009, correct?
My lord.
So from and the default is, when did the default first start?
August 2012.
August 2012. So
The
from
moment-
2009 to 2012, in what manner were you paying the rent?
Well,
When
in-
do you pay the
In
rent?
fact, the tenancy started since the year 1976.
I'm not asking you that. From 2009 onwards,
Well,
does the evidence show?
I'll just point out one more thing, my lord.
Yes.
That
Lordship, due date is concerned, there is no disputed. There is no dispute at all. Neither before learned trial court nor before
So
first
there
week
is
of
no
court.
dispute.
Not disputed.
So
Rather,
according to the agreement, what is the due date?
first week of every month.
First week of every
Lordship,
month.
if your lordship kindly peruse cross-examination, due date is concerned, the tenant PW1 admitted the due date also.
You show me that
Yes,
when your
yes, I
turn
will.
comes. I just wanted to be clarified. So the second party have to pay the above mentioned house rent to the first party within the first week of each and every completed month as per English. So that means if you are for the month of September, the rent will be paid first week in October. Is that correct?
Every subsequent month, lordship.
Isn't it? Subsequent. That's right. So September
September,
rent
October
will
and
be
October.
paid in the first week of October.
October. That is
Correct.
the due date. Yes.
Which is little unusual because generally it is the advanced month which you are required generally
as
to be
per
paid.
commercial tenanted premises.
Correct. But be that this agreement visualizes paying in the subsequent month.
And
The
there was
first
another
week.
practice also, my lord, that landlord used to hand over his electricity bills, which I used to take to the
No, that
electricity.
is a different aspect. But as for due date, this court finds that there is a clause in the agreement. Yes, go
There is a
ahead.
clause in the agreement, but the learned trial court has not
We
discussed
will
about
see.
the same
We will
clause.
see.
My lord.
And then
Then subsequent, my lord, there is another point that, my lord, the landlord used to hand over his electricity bills unto me, my lord. So since the month of August 2012 till December, I used to pay his electricity bills, and beforehand also I used to pay, my lord, prior to August
all right,
2012.
let us see the trial court first.
My lord, trial court judgment will find at, my lord, page number 26.
অলপ টাইম লাগিব যাব খুজিলে যোৱা মই মাতি দিব পাৰিম Yes.
And my lord, the relevant portion that is at paragraph number 17, page 36, my lord.
Page number?
Page number 35, paragraph number 16, where issues number 3 and 4 has been discussed.
Page number?
Page number 35.
35. Issue number 4.
Issue number 3 and 4. Those are the main issues.
Whether the defendant is defaulter in payment of rent and whether the plaintiff is entitled to realize so and so being area
Area
rent
rent.
from the defendant. Yes.
May I read, my lord? Para 16.
Yes.
The present
So
suit-
appellate court concurred the
Concurred
findings
with-
of the trial
My
court,
lord, my lord.
and against that you don't have a second appeal.
No. As per the decision of this honorable, second appeal is, my lord, prohibited also as per
And this is revision.
revision under 115 is there. The present, para 16, my lord. The present suit is instituted by the plaintiff for a decree of recovery of area rent of rupees 16,800 from August 2012 to February 2013, and further rent till exactment of the defendant from the suit premises along with other reliefs. The plaintiff in his plaint as well as evidence in chief stated that both the sides entered into a tenancy agreement dated 1/9/2009. As per the agreed terms and conditions of the said tenancy agreement dated so and so, the rent of the tenanted premises was fixed at rupees 2,400 only per month, payable on or before 7th day of each month according to English calendar. Accordingly, the defendant paid rent up to July 2012. However, in spite of the plaintiff's repeated request demand, since the month of August 2012, the defendant has failed to pay the rent of the tenanted premises.
Yes.
Para 17, on the other hand, the defendant in his written statement pleaded that after the month of December 2012, on being refused, he had deposited the rent before the court as per law. During his cross-examination, the defendant admitted that he had applied before this court to deposit the rent of January, February, and March 2013 together on 11/4/2013 by NJ case number 1938 of 2013 of Exhibit C series. In his cross-examination, the defendant further stated that there is no mention when he tendered the rent for the January, February, and March to the plaintiff. The defendant in his cross-examination further pleaded that no notice was issued to the plaintiff in the said NJ case. The defendant in his cross-examination further deposed that he had deposited the rent for the month of November 2013 on 3/12/2013 by NJ case number 6097/2013 before this court. The defendant in his cross-examination further deposed that no notice was issued to the plaintiff in the said case. The defendant in his cross-examination further deposed that there is no mention when he offered the rent to the plaintiff for the months of June and November 2013. The defendant in his cross-examination also deposed that in other NJ cases also there is no mention when he had tendered the rent to the plaintiff, and it also shows that notices were not issued to the plaintiff. The DW1 in his cross-examination deposed that although he deposed that he paid the rent for the month from August to December 2012, but to support this fact, he had not exhibited any.
So before there is no evidence that this rent was deposited from August to December.
August to December, my lord, I had not deposited in court. I used to adjust with the electricity bills, man.
So, but post December,
Post-December, I used to.
you have deposited. All right.
Para 18, although the defendant in his written statement as well as in his evidence stated that he is not a defaulter in payment of rent, but from his own above mentioned admission, it is crystal clear that the defendant is defaulter in payment of rent. The defendant claimed that the rent for the month of September 2012 to December 2012 was adjusted with the rent with the electricity bills, but in Exhibit 1, that is the tenancy agreement, nowhere it is agreed between the parties that the tenant shall adjust monthly rent with the electricity bills. In fact, the defendant in his cross-examination admitted the same. DW1 in his cross-examination has deposed that there is no mention about the payment of electricity bill from Exhibit B1 to Exhibit B6.
Yes.
As per provision of Section 5(4) of the Assam Urban Areas Rent Control Act 1972, on refusal on the part of the landlord to accept rent on tendering the same, a tenant can deposit rent in the court.
But till now, till para reading of
Para 18.
16, 17, 18, it indicates from August to December 2012, there was no tendering of rent. There is no evidence showing that you had tendered rent, correct? Post December 2012, it appears that you have deposited in the court. Now, 5(4) says if the landlord refuses, then the tenant can deposit the rent in court.
Within a fortnight.
Yes, please read.
Although the notice to the landlord informing him that although the defendant deposited rent from the month of January 2013 before the court, but no mention were made in the applications when same were offered to the landlord prior to deposit of the same. Moreover, no notice was served to the landlord in any NJ cases. DW1 in his
NJ cases means when you are depositing.
My lord, it is registered as non-judicial case.
Huh?
Non-judicial.
Non-judicial case. This is only for the purpose of
Purpose of
tendering the rent,
depositing the rent.
And in those cases, a notice has to be issued.
Notice has to be
And
issued compulsory.
subsequently, the plaintiff, the landlord can withdraw the rent.
My lord,
Correct.
landlord can withdraw.
So basically, the rent is given through the court
Process of the court, my lord.
Yes.
Notice is issued so that the landlord can come to know
because
that
of for
rent
his
is-
intimation.
My lord.
But here, notices was not given.
Notices were given, my lord. It was not issued by the office. That is a perverse finding, my lord. I had deposited the notice, but the office had not issued.
But that comes subsequent.
Subsequent,
First and foremost is that whether you're a defaulter or not.
my lord.
Still now, it appears for August
August, December,
2012 to December 2012, you are a defaulter.
my lord. Prima facie, it appears.
Prima facie, all right.
It is the moreover, no notice was served to the landlord in any NJ cases. DW1 in his cross-examination has deposited that in the NJ case number 1938 of 2013, there is no report for serving notice upon the plaintiff. It is a requirement of Section 54 of the Assam Urban Areas Rent Control Act 1972 that the deposit of rent in court must be made along with the process fee for service of notice upon the landlord. For the failure of the tenant in taking steps for service of notice upon the landlord, which is mandatory as per provision of Section 54 of the Assam Urban Areas Rent Control Act 1972, it cannot be said that he has paid the rent to the landlord. Apart from it, is apparent that the defendant neither deposited the rent for the month of January 2013, February 2013, June 2013, and November 2013 within fortnight, nor tendered the rent for any month to the plaintiff before depositing the rent before the court, which is required as per provision of Assam Urban Areas Rent Control Act 1972. Therefore, deposit made by the defendant in the court is also not valid deposit. As the defendant has failed to show that he paid rent to the plaintiff from the month of August 2012 to December 2012, and rent deposits made in the court since the month of January 2013 were not valid deposit, the defendant is defaulter in payment of rent from the month of August 2012. It is also settled principle of law that once a defaulter is always a defaulter. The defendant had to pay the rent to the landlord as per the terms and conditions of the agreement, and on being refused by the landlord, the defendant had to pay the rent before the court as per provisions of Section 54 of the Assam Urban Areas Rent Control Act. The Honorable Guwahati High Court in judgment reported in so and so held that the protection is available to the tenant if he complies with the requirement of provision of Section 54 of the Assam Urban Areas Rent Control Act 1972. The Honorable Guwahati High Court further held that it is the mandate of Section 54 of the Assam Urban Areas Rent Control Act 1972 that rent must be offered to the landlord before depositing in
So
court.
here there is evidence that it shows that you have not offered to the landlord before depositing the
Tendering
the
part,
court.
my lord, that is missing in the
So that is why the court saying that is not valid.
That is
correct.
But in my written statement, in paragraph number
We'll
9,
come to that, but I'm trying to understand.
Well,
As per the trial court
Trial
order,
court.
these are the
there was no
reasons.
tendering of rent. DW1 in his cross-examination deposed that he deposited the rent for the month of June on 27/6/2013 in the court through NJ case, which is not valid deposit as per terms and condition of the tenancy agreement and the mandate of law. The rent is to be deposited when it becomes due. The rent for the June will become due within the first week of the succeeding month, that is July 2013. The Honorable Guwahati High Court in judgment so and so held that the tenant is under legal obligation to pay the monthly rent during pendency of the eviction proceedings. It is also held by the Honorable Guwahati High Court that rent deposited in advance in the court cannot be considered as legal tendering of rent. In the same judgment, the Honorable Guwahati High Court held that the rent deposited unilaterally is not consistent with the procedure prescribed by Section 54 of the Assam Urban Areas
Just,
Rent.
let me just have a look at 5.4.
5.4.
Five is bar against passing and execution of decree.
My lord, that is protection given to the tenant.
4. So there has to be a refusal,
Refusal.
and then within a fortnight. These are the conditions.
Firstly, my lord, there has to be a tender, then it has to be
Correct.
refused, then within a fortnight of the refusal, I have to pay it before the learned court.
And after such deposit, court shall cause notice,
My lord, that has to be deposited with a process fee along with the notice. That is mandatory.
which you had done.
I had done according to me.
All right. Yes.
Para 22, as such, the plaintiff is defaulted in payment of rent and plaintiff is entitled to realization of rupees 16,800 being area rent for the period of August 2012 to February 2013 from the defendant as paid by him. The plaintiff is also entitled to future rent from the defendant since March 2013 till his ejectment. So this is how, my lord, the point of defaulter was dealt with.
Now, bona fide.
Bona fide requirement. But, my lord, bona fide requirement was not at all discussed by the appellate court.
All right.
My lord. Issue number 7, next page, man. Page 40. In the present
See,
suit,
appellate court has affirmed the
only on the
judgment.
ground of defaulter, my lord, not on bona fide requirement. That is quite.
That may not itself make it invalid.
I'll just come to the point. I'll show, my lord.
Because sometimes I think there are also decisions to the effect that if all the points determined is not discussed, that will not, because here the appellate court has affirmed the findings of the trial court. Correct.
Only with regard to defaulter.
Now, is it that both the conditions has to be fulfilled?
My
No,
lord.
Lordship. One of the ground is only enough.
You apprised because you both of you enlightened me.
Because Order 41, Rule 31, it strictly mandates that, my lord, if 2 points are there, 2 issues are there, both has to be dealt with independently.
We'll
and
see.
since in the present suit, the plaintiff also seeks ejectment of the defendant on the ground of bona fide requirement of the suit premises for the plaintiff and his family members. In para 4 of the plaint, the plaintiff specifically states that the premises presently occupied by the defendant are required bona fide by the plaintiff for himself and his family members for their own commercial use. Therefore, the plaintiff and his son wants to start their own shop business, and the premises presently occupied by the defendant is ideal one for the said business. In support to the claim of the bona fide requirement, the plaintiff has adduced his evidence as well as evidence of his unemployed daughter as PW2 and one Raju Chaudhary as PW3. The plaintiff in his evidence in paragraph 5 stated that I have an unemployed son and widowed daughter having 3 minor sons. The premises presently occupied by the defendant is required bona fide for commercial use, wherein I want to start my own family business.
All right. So there is evidence showing that. Yes. Yeah. All right. Read.
For employment of my son and widowed daughter. Premises presently occupied by the defendant is ideal place for my own family business. The defendant failed to disprove the fact of plaintiff at the time of cross-examination. But, my lord, may I just point out one thing, my lord? In the cross-examination, my lord, PW3 as well as the PW1, they have accepted that the plaintiff's son is not unemployed. He has his own gym and he has also rented out properties to Union Bank of India. The daughter of the plaintiff who adduced her evidence as PW2 in para 6 of her evidence stated that after the death of my husband, I along with 3 minor sons are completely dependent on the earning of my father, that is the plaintiff of the present suit, who has only rental income. Therefore, my father now wants to start our own business, as we have previously experienced.
PW2 is the daughter of
the
and PW3 is
3 is independent witness, my lord, one of the neighbors of the.
and 1 is.
1 is the landlord himself.
So there are prosecution witnesses are how many?
3.
So
Total 3.
no, these are in the civil code. It is not prosecution witness.
Plaintiff's witness.
Plaintiff witness. 3 plaintiff witnesses. And defense witnesses, defendant.
Only 1. The tenant himself.
PW1 is the landlord. PW2 is the son.
Daughter of the landlord.
PW2
2 is the daughter of
is
the
the
landlord.
daughter.
PW3 is an independent witness.
Who and they said this is required for the son.
Son.
He is
Unemployed
not.
son.
He is not. He has not given deposition.
He has not come to deposit.
And who is this independent witness?
PW3, man.
No, who is he?
He is one of the person who stays near the locality, man.
So he
He has admitted, my lord.
admitted that the premises is required for
Bona fide requirement.
for the unemployed son.
Unemployed son.
Where
But the
he
son
wants
is not
to-
unemployed.
That will
That he has
come,
admitted.
but yes.
That after the
See,
death
whether
of my,
he's unemployed or not employed, but if they want to open a shop there,
to augment the income, my lord. But still, my lord, they have
How
another
can
7
you-
shops, my lord.
Huh?
They have another 7 shops.
so if they have 7 shops, they cannot have a 8 one.
That my lord will decide.
Huh?
That my lord will decide.
How can you or I
Dictate.
dictate that to the owner of the space? If he wants, he wants. It is bona fide. It is not for something else. Anyway,
But this paragraph that I am reading, my lord, paragraph 27, 6, my lord, this is not a part of the pleading, my lord. This has come only
Not
in
part of the pleading.
not part of the pleading. Evidence that after the death of my husband, I, along with 3 of my minor sons, are completely dependent on the earning of my father, that is the plaintiff of the present suit, who has only rental income. Therefore, my father now wants to start their own business. As we have previously experienced a footwear business, now we want to start our own business with my father in the suit premises.
So it appears that even she wants to start.
She also wants to start.
Yes.
In this regard, we have already made contact with several stockists of the
Does
food.
this corroborate with her father?
Father says that he wants to start a shoe business.
Okay.
Only that part corroborates. In this regard, we have already made contact with several stockists of the footwear for providing goods, and one of its measures, Kamru Footwear, situated at Colonel J. Ali Road, Laktokia, responded for the same. The premises occupied by the defendant is ideal for footwear showroom business. Therefore, the premises presently occupied by the defendant is required for a family commercial use. In cross-examination, PW2 deposed that in the building wherein the suit premises is situated, her father had a footwear shop in the name of First Step. It is further deposed that she made contact with an association for running their footwear shop. She had not submitted any communication letter, but she had submitted a letter, that is Exhibit 38, before this court. The PW3 also in his evidence in para 3, 4, and 5 stated about the experience of footwear business of the plaintiff, as well as bona fide need of the suit premises for their family business of the plaintiff for their livelihood. However, the defendant did not ask any specific question to disprove the facts of the plaintiff at the time of cross-examination. Apart from the facts and evidence of the plaintiff's side with regard to bona fide requirement, the defendant himself admitted in his cross-examination that earlier, Ajadur Rahman, that is the landlord, had footwear business, but at present he has no business. He has a daughter and 3 sons. At present, the daughter of the plaintiff stays with his father.
All right, I've read para 30.
Well,
Yes.
so discussing all these things, madam, and concluding that bona fide requirement was in favor of the
Yes.
landlord. And accordingly, my lord, the suit was decreed. Now, my lord, it comes to page number 54, that is the appellate court judgment, and discussions, my lord, will find at page number 58. Excuse me. PW1,
This appeal is filed under?
file 96, my lord, 96.
Yes.
PW1, the plaintiff in his evidence deposed that the defendant defaulted in payment of rent since the month of August
Where
2000.
are you reading from?
Page 58, my lord.
58.
Para 6. Right. My lord has got it. Para 6. PW1, the plaintiff in his
No,
evidence.
before decision, the point determinations have been laid down.
My lord, point of determination is not laid down. On issues were there. As per order 41 rule 31, points for determination has to be done.
That is not done.
not done. That is my contention.
Yes.
PW1, the plaintiff in his evidence has deposed that the defendant defaulted in payment of rent since the month of August 2012 and did not pay rent in spite of repeated demands, and thereafter advocate notice was issued to the defendant dated 1/3/2013, demanding area rent, and the defendant was asked to vacate the suit premises. That Exhibit 37 is the advocate notice. The tenancy agreement marked as Exhibit 5 dated 1/9/2009 is not disputed. PW1, the defendant in his evidence denied that he is defaulter, and in his evidence deposed that the plaintiff received rent at the revised rate up to 31/12/12, and the plaintiff used to hand over his personal electricity bills to the defendant for payment and adjusted the deed amount against the rent while issuing rent receipts for the respective months. DW1 deposed that the plaintiff accordingly till October 2012 received the rent for the month of September 2012 after adjusting the electricity bill, but thereafter stopped asking the defendant to pay the electricity bill and received the rent in full up to December 2012, but stopped issuing money receipts for rents paid for the month of August 2012 onwards. In his cross-examination, DW1 deposed that the electricity bills are exhibited as Exhibit B series. On perusal of Exhibit B series, we do not find any evidence to show that the bills were adjusted against the rents payable by the defendant. DW1
The
deposed,
appellate court has reappreciated the evidence.
my lord, only with regard to defaulter point.
All right, we will see.
My lord, against the rent payable by the defendant. PW1 deposed that the defendant defaulted in payment of rent since the month of August 2012 in respect of the tenanted premises.
Because this court, while exercising revisional jurisdiction, cannot go into all this now.
Now,
The appellate court
Until and unless
is
there is
the
perversity.
finding fact correct. You have to show me something
my lord, until and unless-
jurisdictional. Right now, the entire exercise is to see if there is a jurisdictional error, isn't it? Because it is 115. The error has to be jurisdiction one.
Jurisdiction.
Nothing beyond.
Nothing.
Powers of 115 has been curtailed. Is my understanding correct or not? Mr.
Correct,
Iqbal?
correct.
Yes.
PW1 deposed that the defendant defaulted in payment of rent since the month of August 2012 in respect of the tenanted premises, and DW1 deposed that the plaintiff received rent till the month of December 2012, but did not issue any money received since August 2012 and stopped receiving rent from December 2012, and so the defendant started to deposit the rent in court. On perusal of the tenancy agreement marked as Exhibit 1, it is seen that the rent is to be payable within the first week of each and every completed month as per the English calendar. DW1 deposed that he deposited the rent in court, and the NJ cases are exhibited as C series. DW1 in his cross-examination stated that he deposited the rent for the month of January, February, and March 2013 together on 11/4/2013 by NJ case number so and so. On perusal of Exhibit E1, which is the challan in respect of the deposit of rent for the month of January, February, and March 2013, it is seen that an amount of rupees 9,000 was deposited on 11/4/2013. This is in gross violation of the tenancy agreement, Exhibit 1, as the rent was to be payable within the first week of the succeeding month for which the rent has become due. The defendant, in order to save himself from
So
being
there is a finding to the due date also.
Here, my lord says subsequent month, but in the previous paragraph, it is said that, my lord, completed month. Whether subsequent.
Completed month means that only. Well, after the completed month. What do that mean? Once the September is completed, then in the next month they will pay. It has to mean that only. There cannot be any other mean.
Well, my understanding, my lord, is that, my lord,
unless it says advance of the completed month, then the word advance has to be there.
The word advance is also not there in the agreement, and
that's because it is not an advance payment.
My lord.
What both
And
parties
subsequent-
visualized in this agreement is that the month will be completed, and thereafter in the next month, in the first week, the completed month's rent will be paid. Isn't it?
My lord.
This appears to be the be that as it may, both the codes below have both the codes, trial codes. I keep saying below, but it is not correct anymore to refer to the trial court as either lower courts or subordinate courts or below, because they are not subordinates. So I keep correcting myself. Yes.
This is in gross violation of the tenancy agreement, Exhibit 1, as the rent was to be payable within the first week of the succeeding month for which the rent has become due. The defendant, in order to save himself from being a defaulter, ought to have deposited the rent in court within a fortnight of the rent becoming due, but as the rent for the month of January, February, March were deposited on 11/4/13, the defendant thus violated the terms of the tenancy, and so the deposit by Exhibit E1 cannot be said to be a valid deposit of rent in court. Para 8, DW1 in his evidence deposed that the landlord plaintiff received the rent for the month of August 2012 to December 2012, but could not prove the same by adducing any reliable evidence. The defendant also failed to prove that the rent was adjusted against the payment of electricity bills of the plaintiff by the defendant. Para 9, the Honorable Guwahati High Court in the case of Abdul Mateen Chaudhary and so-and-so held that the tendering of rent to the landlord within a fortnight of its falling due is a precondition to the deposit of rent in court. Section 5(4) of the Assam Urban Areas Rent Control Act states that where the landlord refuses to accept the lawful rent offered by his tenant, the tenant may, within a fortnight of its becoming due, deposit in court the amount of such rent together with the process fee for service of notice upon the landlord, and on receiving such deposit, the court shall cause a notice of such receipt of such deposit to be served on the landlord, and the amount of deposit may thereafter be withdrawn by the landlord on application made by him to the court in
All right.
My lord.
All right.
A tenant has made such deposits.
You are right. There appears no discussion as regards the bona fide.
Bona fide requirement. That was incumbent because, my lord, the first appellate
now under the Assam urban areas rent control act,
my lord,
which section says about the bona fide requirement? Section 5.
5 only, my lord. It
Where?
is
Subsection 3.
my lord. My lord is using that book.
Yes.
Subclause 6 is there, my lord.
Subclause 6 of
Section 5, my lord.
Section 5.
I'll just come.
Section 5.
Bona fide requirement, my lord, 13. 5, section 5, 13, clause C.
1 second. Why? Is this not the one? The urban. There are some urban areas rent control Act 1972.
My lord, that is the one.
Section 5 has no 13 in my book.
It's
Mr. Iqbal, just have a look.
my lord.
I want to see where from the two requirements that one has to be that the tenant has to be a defaulter and that the landlord requires it for a bona fide reason. Where does this two condition comes from?
Here, my lord, it's given little bit differently, my lord.
Yes.
In my book, it is completely different. My lord.
How can it be? Are we not referring to the same?
Same act, but my lord. If my lord sees my book,
But is that not a new edition?
this is a new edition, my lord.
Then, yes, Mr. Ali.
We are using the same book. My lord.
Same book, Lord, sir.
Just have a look about the court's book. Is it not the same act? Because section 5 is only having
Same,
4
same,
subsections.
Same, Lord, sir.
Then have a look, section 5. I think I have already flagged it.
Even promotions will be 732.
732.
32.
It's actually the entire principle of Assam Urban Area Rent Control Act based on section 5.4. That is 4 or 5 precondition regarding a duty of the tenant. The bona fide requirement is additional ground.
Where does it come from? Just show me that provision first.
Not definition. In this act also definition clause is also not there.
It starts with a definition of bona fide requirement.
It's not there.
That is also not
They're not there.
One second.
Maybe explanation.
Thank you very much.
Not there. This is not there.
It's not there. Where is it not there?
Lots of
In my book. Is that the
both book.
the same?
A definition clause is not here. Normally, it's in every act. Definition
Pilot-
clause is to be there,
Pilots,
but there is
in
no
our book it
definition.
is there. 15 and
Yes, Mr. Iqbal.
This act is very old act and
Well, this one is what we
BK
follow.
was some sure.
Oh.
13.
Milos is page 89. The definition, scope, everything is given. Page 89, clause 13, clause C.
This is the commentary, Mr. Iqbal. Where is the section 5? Yes. Mr. Iqbal,
My lord,
section 5 is the same section 5. It is there at page 62 in your book. And this clause
62.
13,
my lord,
which you are showing,
my lord.
is the commentary of the author.
Yes.
But at least, my lord, the scope and the definition.
Now you are going to rely on commentaries.
No, no, my lord, I'm not.
Where is the decision? See the flag portion. You cannot be relying on commentaries of authors.
Not
part of the additional ground. Time to time discuss the definition concept.
Do you have the decision of this court in Rashmi Deka Vaisaw's case?
My lord.
You're carrying it.
My lord.
Let's go there. Let's see what is. First, let us understand this, and then we will go to the next point, whether what is the jurisdictional error.
My lord.
Because as far as 115 is concerned, I am going to be only confined to the jurisdiction aspect. Nothing more, nothing less. Because that is what I can do sitting in
Under
115, isn't it?
Yes, my lord.
But before that, let us, since you are saying that bona fide requirement has not been dealt by. But for that also,
But for that, my lord, if my lord allows me, I have a Supreme Court judgment, my lord.
yes, why will I not allow you, Mr. Iqbal? Yes. Supreme Court judgment in which case?
My lord, 2011 4 SCC,
All right.
It's-
I have one of 2017.
2017, my lord.
See if you're carrying a mobile, you can just see if you have the app there. 2017 volume 2 SSC 415. 2017 volume 2 SSC 415.
Paragraph 17 and 18, if my lord comes.
1 second. Yes, paragraph
17 and 18, my lord.
relevant issues. But what I was thinking is, suppose the court has come to a finding that yes, you are a defaulter. In such a situation, does it also require that the landlord requires the premises for a bona fide requirement? Both the condition of defaulter and bona fide requirement has to be fulfilled.
My lord.
Is that so?
Only-
If so, which is that law?
My lord. Only on one ground, my lord, I can be evicted, even if. But
Correct.
my case is that, my lord.
No, I understand. I am following your point. But what this court first wants to know is if either ground satisfied.
My lord.
Correct. Now
I
it
can be
appears that before the appellate court found that the reasoning given by the trial court as far as the defaulter is concerned is valid.
My lord.
And thereafter the trial court affirmed the view of the appellate court affirmed the view of the trial. This is what has happened, correct?
Right.
Now, since I'm exercising 115 here, what is the jurisdictional error? In support of your contention, you are saying that it was the bounden duty of the appellate court to draw up the point of determination and give a finding in respect to each of the points.
My lord.
Here, firstly, there was no determination of points.
Points.
Secondly, the two issue which the trial court had framed and as regards defaulter and bona fide, the appellate court has, on the basis of the defaulter, affirmed it. There is no discussion as regards bona fide. Now, here there are two ways of saying, just because you see, because you're a defaulter, you're entitled to the to be evicted.
My lord.
Correct.
My lord.
This the trial court and the appellate court has found.
My lord.
Maybe this is why the appellate court did not go to the subsequent issue. Now, because of that, can you say the appellate court had exercised his jurisdiction wrongly? This is, you think over. I'll come back in 5 minutes. You apprise this court of that, because just because the determination points of determinations have been not laid down, and each points on which the trial court had the issues that the trial court has framed, the appellate court has not discussed or to the relevant. That is why the appellate court order is erroneous as per in law. You show me something.
My lord.
Okay.
She recorded the substitution. The original suit was filed by somebody. He was substituted, but that substitution has not been pointed out in the paper book.
So let me say that there is some defect as regards the paper book, and you all point it out to the registry.
Okay.
I'll give liberty to the councils to point it out to the registry, and registry shall thereafter do the needful.
Yes.
Is that
Yes,
all right?
sir.
Because
Yeah.
otherwise it's difficult.
Difficult.
Item 1 and 2.
One and two.
It's a common paper book.
Come on, Lordship.
Item 1 and 2. Click here. It is submitted at the bar that there are certain defects in the paper book prepared by the registry of this court. Stop. In view of the aforesaid endorsement made by the learned counsel for both sides, comma, let registry rectify the defects and place the rectify the defects. Stop. Needless to clarify that counsels for both parties are at liberty to point out the defect before the registry within a period of
2 weeks, Lordship.
2 weeks.
Lordship. Okay.
2 weeks.
Lordship, it might take.
You just have to point out the defect.
Just now we have found
Only one defect.
one defect. If there are something or other, then we have
How
to
much
verify.
time will you take to look into all the defects? All right, within a period of 1 week from today.
Lordship.
Stop. List after 2 weeks
Lordship.
on a date to be fixed by the registry.
Yes.
Much obliged.
Yes.
Before my learned friend
Yes,
starts, my lord. My lord, may I permit, my lord? I have a small prayer, my lord. My lord, item number 8, my lord. I could not come, my lord, because
Item
I
8.
was stuck in water, my lord, on the road.
I think we have given some order.
My lord, it has been, my lord, 1 week, adjourned for 1 week.
Order
That
is
is the order.
passed, Mr. Counsel. Yes.
My lord, can a date be fixed, my lord? Otherwise, it
The
won't be
order has
disturbed.
been already passed. It's typed out and already signed. Yes.
I am obliged, my lord.
My lord. With regard to the jurisdictional error, my lord,
Yes.
may I
This
just
case that you are relying, Mr. Iqbal, this case is first appeal or order
This was-
41?
order 41.
Not
first.
it is not 115.
No.
Yes.
My lord, with regard to the jurisdictional error part, my lord, that's what, my lord, order 41, there was a jurisdiction vested upon the learned appellate court below, which it has failed to exercise, my lord.
In the manner.
My lord, as prescribed under law. Secondly, my lord, if my lord comes to page number 36 of the judgment,
Which
of the
judgment?
trial court judgment,
Yes.
page 36, the learned trial courts, my lord, they have considered certain facts after institution of the suit and not prior to the institution of the suit.
Please don't unnecessarily go to those.
just because Rasmi Deka Boiso case is there, my lord.
But you have not taken up before the trial court, appellate court, and now you are before 115.
Point of law, my lord, that's right. It's a point of law, that's right.
What is there?
My lord, paragraph 36, my lord. I'll just read from the middle portion. The defendant in his cross-examination further deposed that he had deposited the rent for the month of November 2000. My lord has got.
Yes.
November 2013 on 3/12/2013 by NJ case number so and so. Defendant in his cross-examination further deposed that no notice was issued to the plaintiff. The defendant in his cross-examination further deposed that there is no mention when he offered. So, my lord, this part November 2013, my lord, suit was instituted in the year March 2013, my lord. So, if I had defaulted in the month of November 2013 or after March 2013, my lord,
No, in your cross-examination, it is given what?
It is correct, my lord. November 2013, my lord, maybe I had defaulted or maybe I have not followed the rules prescribed, my lord. But if, my lord, I have to be considered as a defaulter after institution of the suit, the landlord has to file an application to bring
That's all
this-
right. You have already, there are evidence showing that you are a defaulter from
why I'm
from
saying,
August to December,
Well-
and thereafter also whatever you have deposited in the court is not
After
forthwith,
fortnight.
is after forthwith.
that is,
So those findings are already there.
considering this, my lord, I have
No,
been
no, this court will not get into all these facts, and those findings are against you. Now the only question is, just because the issues have not been, the points have not been determined in the manner it ought to have been determined under Order 41, whether for that reason alone it can be said that there is a jurisdictional error. Can that be a jurisdictional error? Please address on that.
My submission is that, my lord, the first appellate court being the final court of facts and law, my lord, it was incumbent upon the court, and as has been held by number of catenary decisions, my lord, that it is a mandatory provision and it has to be followed.
No, non-following of that is a jurisdictional error. You
My
have
lord,
anything
because
on
there
that?
was a jurisdiction vest. I don't have any judgment, my lord. But
Yes, Mr. Ali. Anything else, Iqbal? Mr.
My lord,
Iqbal? Yes.
If you honor kindly peruse first plan, what is
Mr.
my
Ali,
case
you've
exactly?
understood what is going on in
Yes,
the
yes,
minority court, because this court finds that both the trial court and the appellate court has appreciated the evidences and has, by reasons,
Lordship.
declared that the defendant is the defendant is a you are a defendant,
Defendant.
that the defendant was a defaulter,
Yes, Lordship.
and passed the order, right?
Lordship.
Now you are one is it before a very limited jurisdiction.
Lordship. Lordship. That is
All
the-
this
I have
court has
raised
to
also some
confine
judgment.
is to a jurisdiction.
Yes.
The argument is that non-following the procedure laid down in Order 41 for an appellate court, specifically for not determining the points of law and facts involved, and also not giving any reasons or discussing the bona fide issue, the appellate court has not exercised the jurisdiction in the manner it has been given.
Lordship.
This is the argument,
Lordship.
and therefore it is erroneous.
Lordship.
This is the argument.
Yes, sir.
Yes, whether that can stand,
Lordship, definitely.
right?
What happened earlier? What happened, Lordship? Actually, matter was heard by Honorable Justice.
You are going to burden me with 13 judgments.
Yes, Lordship. All are.
I was thinking I will dictate a judgment in court. Just give one judgment. One judgment is sufficient. I just want a judgment that this cannot be, if you have that such a non-exercise, non-determining the points is not a jurisdictional error. It can be an irregularity, but it is not touching the jurisdiction.
Lordship. I also have written from record. Also. Earlier also.
So that you cannot show from record. That you cannot show
What
from
is
record, because the
available
record
regarding-
indicates that the appellate court admittedly did not draw up the points.
Lordship.
Where has the appellate court determined the points? The appellate court has not.
As per section 5, subsection 1 proviso said one of the ground is necessary. I will show everything
5?
continuously.
Five?
5. Section 5,
Yes.
subsection 1 proviso.
Yes.
Here,
Please
Lords-
read. Read.
Lordship. Proviso. Here, your Lordship will find A to E, F,
Yes,
A
yes.
to F.
Yeah.
Landlord can file suit for on the basis of any of the ground, Your Honor. Here, first ground
Mr.
is
Ali, this court is asking you to read. Please read it.
Lordship. A.
Yes.
Where the tenant has done
No,
anything
read
contrary.
from one. Read from one. No order.
No order or decree for recovery of possession or any house shall be made or executed by any court so long as the tenant pays rent to full extent allowable under the act and performs the condition of the tenancy. Proviso. Provided nothing that nothing in this subsection shall apply in the suit or proceeding for eviction of tenant from the house. A. Where the tenant has done anything contrary to the provisions of clause M, clause O, or clause P of the of section 108 of the Transfer of Property Act, or to the spirit of aforesaid clause in areas where the said act does not apply, or these are all, Lordship, where the tenant has
All
been
right, I've understood.
Yes.
Bona fide is C and
C,
E is
C.
defaulter.
Yes, yes.
So either C or E.
E.
So
One of the
here,
ground.
this is why I was saying that the court has already come to a finding that one is a bona fide, defaulter.
Defaulter.
Now, after coming to that finding, strictly speaking, it is not necessary for going into the issue whether bona fide requirement is there or not, because the court is already satisfied that he is a defaulter.
Yes, yes, yes. Here, your Lordship
This is
will
one of
find-
my.
Here, Your Honor will
Technically, I
find-
may not be correct. We will
No, my
see
lord is
to it.
absolutely correct.
Here, Your Honor will find word or.
I have seen.
Yes.
All right.
If Your Honor kindly peruse first plant. What was
First what?
Plant.
Huh?
Plant.
Plain.
Plant. Annexure 1. What was my case exactly? I will read out only relevant portion.
Yes, please.
Paragraph 3, Lordship will find at page 12. Revision petition, Lord.
Yes.
Paragraph 3. As per terms of the tenancy agreement dated 1/9/2009, entered between plaintiff and defendant, the rent of the tenanted premises was at fixed at rupees 2,400 only per month, payable on or before 7th day of each month according to English calendar. Next paragraph, Lordship. That the tenant has failed to pay the monthly rent to the plaintiff from the month of August 2012. And for this, the plaintiff has already requested the defendant on several occasions to clear all the area rent, but the defendant has failed to do so. Thereafter, on 1/3/2013, the plaintiff, through his advocate, sent a legal notice to the defendant demanding all area rent and to vacate the tenanted shop room. In spite of receiving the said notice, the defendant neither paid the area rent due nor vacated the tenanted shop room. Therefore, the defendant has lost the status of tenant and become a defaulter. And then kindly peruse very short 5-line paragraph 5 at page 13.
Yes, bona fide.
Bona fide. The premises occupied by the defendant is required bona fide by the plaintiff for himself and family members for their own commercial use. This is independent sentence, Your Honor. Here, they are very specifically
All right,
said.
Mr. Ali, I've understood
Yes, yes.
that you do, in your case, both the conditions condition C and E is applicable.
Yes.
However, it is not required that both has to coexist.
Yes. Yes.
Even if one is available, you have a case for rejection,
Yes.
correct?
Yes. If Your Lordship kindly peruse their reply, written statement, Annexure 2.
Yes.
Reply against defaulter.
Yes.
Paragraph 8, page 18.
Paragraph 8.
Paragraph 8, page 18.
Yes.
The defendant denies the statement that he has failed to pay rent from August 2012, that there arose any occasion for plaintiff to issue any legal notice, and that the defendant received any legal notice dated 1/3/2013 from the plaintiff regarding demanding area rent or asking to vacate the tenanted shop room as stated by the plaintiff in paragraph 4 of the plan.
This has already been rejected by the trial court
Rejected.
as regards electricity bill contention.
Yes, yes. So, my humble and respectful submission, Lordship.
Mr. Ali, on facts, this court is with you. So you come to the specific query, the jurisdiction, if you have anything to show in support. Because on facts, it appears that you have a case. There's no doubt. I'm expressing my anxiety so as to save the time. Because there is no, if this court is convinced on that, and most importantly, this is not a court, this court is not to go into the facts, isn't it, Mr. Iqbal and Mr. Ali? So, but be that as it may, the court will obviously see whether the trial court and appellate court has correctly come to the, so that it appears they have. There are reasons given. I don't find any jurisdictional error in the approach of the appellate court as regards affirming the views of the trial court as far one of the issue is concerned. But existence of that issue itself is sufficient for the relief sought in that suit which has been given. Correct. So on that, I think there is no infirmity. Now the question is, just because the Order 41 also lays down the manner in which the appellate court has to determine the suit, determine the appeal, correct? Isn't it? First is determination of the points involved, reasons. Now here, apparent no determination done. Be that as it may, the trial court has discussed the relevant issue of defaulter.
Yes.
And has given its reasons for affirmation.
Order 41, Rule 31.
That has been done. In spirit, it may not have been followed, but this order cannot be said to be perverse because there is a discussion as regards defaulter issue. And that issue itself is sufficient for ejection. So to that extent, I don't find there is any jurisdictional error. So therefore, I'm asking from both sides, if there is anything, show me.
What happened?
Yes.
There is several category of case which normally filed before civil court. That's it. That a case of landlord and tenant is regarded as suit for simpliciter, like Section 6 case. Those are suit for simpliciter. In fact, against the suit of Section 6, no appeal is also lie. Directly 115 under CPC. Like tenancy suit also regarded as suit for simpliciter. So in this case, Lordship, Section Order 41, Rule 31 not strictly applicable. Here, Lordship has to decide only one of those grounds. Only one of those grounds, not entire necessary law. Here, other suit is concerned.
Which is the decision to show that this is a suit in simpliciter and Order 41 is not strictly applicable? Which is the authority that you're carrying?
Yeah, I have not available here at this stage, but it's a normally.
No,
follows.
but
Yes.
I would require you to show me because
that is-
I am new as far as this arena is
Yes, yes.
concerned. You'll have
Yes.
to enlighten me
Yes.
if you want an order from this court. Yes.
I will try to assist. If Lordship already realized the power of 115, I have placed here judgment of one judgment of her. This Honorable High
115
Court.
is all right. This court.
Yes.
Anyway, what do
Everything
you want
is
to?
there.
Which one you want to rely for 115?
One Honorable Supreme Court that is reported in 1991 ARSC page 455 flag 1
This is pre-amendment.
pre-amendment, but pre-amendment.
All right.
If your Lordship kindly
But
peruse,
these are not otherwise relevant as far as this case is concerned. You come to the question which the court is faced with.
no jurisdictional error at all. Lordship, if your Lordship kindly peruse the decision of learned trial court regarding issue number 3 and 4, that is with regard to defaulter. If your Lordship kindly peruse the cross-examination, for a moment, if Lordship allowed to read some effective part of cross-examination, everything based on record. Learned trial court as well as
Mr.
first
Ali,
appellate
how
court.
many times this court has to tell you that on facts this court is with you?
Yes. But
Please answer the question that the court has put.
no jurisdictional error, Lordship. A learned trial court as well as first appellate court rightly considered all the materials available in the case record. And Your Honor, will find one decision of our High Court, flag number 5A. Flag number 5A.
One
of my-
second.
They have admittedly the tenant deposited rent of January, February, and March together. That itself is enough to hold him as defaulter. Flag number 5A.
Flag number
5A. Decision of our High Court reported in 2015 3 GLR 636. Paragraph 10. Here in this case also, at the time 6-month area rent was deposited. Here in this case also 3-month rent was deposited by single NJ cases.
the fortnight requirement is not
Yes,
complied.
not compliant. So similar almost. Here,
For
6
that,
months
you
here-
don't need a decision. It is clear in the act.
And regarding their stand of not defaulter, I have placed a judgment of Honorable Supreme Court that is reported in 2016, flag number 13.
All right.
Here, the Honorable Supreme Court categorically held in paragraph 16. The effective court, Lordship, cross-examination not only a matter of procedure, but that of substance. Non-cross-examination of witness defect not disputed the statement in the witness. If a witness is not cross-examined, his
All right,
statement
one
will be
second.
deemed to have
Mr.
been
Iqbal,
accepted.
that decision that you have given for to show on the first appellate court's powers, even that decision itself says that while exercising power under Order 41, Rule 31, it must be evident from judgment of appellate court that court has properly appreciated facts, evidence, applied its mind, and decided the case, considering the material on record, which appears it has been done in this case.
Hello. My submission
And just because the bona fide
word is not.
you see, that is otherwise also non-consideration of that issue will not be fatal, because one of the requirement is that in this case the appellate court has come to a clear finding that you are a defaulter,
My lord.
supported with evidence, appreciated, reappreciated.
My lord.
Now, if after considering that this court feels there is no infirmity,
Because otherwise, my lord, that fortnight issue, my lord, January, February, March. That, my lord,
yes, because I don't think I need to go into all that aspects so much,
My
because
lord.
these are factual aspects. Both the courts have given their findings. This is not even a second appellate court. It's a revisional court. All that this court is concerned is the jurisdictional error, isn't it?
My lord.
So I don't find there is any jurisdictional error. The two grounds that you have argued on jurisdictional error, one is the point of determination not drawn. All right, not drawn. But that itself will not make it a jurisdictionally erroneous decision. Number one. Number two, you have said that bona fide, which is also one of the issue, was not discussed. Not discussing of that is also will not be fatal to the case of the defendant, because one of the ground, which is
Defaulter
it
is
is one of the ground under Section 5. Correct. Anything more on that?
Nothing.
Lordship, a matter
So
of
I am going
earlier-
to post this matter for delivery of order on Thursday.
This Thursday.
Arguments, I am taking it to be completed. I'm going to dictate the order in open court. That is why I'm posting it on Thursday. Before that, if you get that decision, which you have said that simpliciter, Mr. Iqbal, you can also assist the court on that part.
Otherwise on 10, 11, 1.
I am with you, Mr. Counsel.
That's it.
How many times I have to indicate that?
That's it. No, otherwise,
You are thinking you have a weak case.
no, sir. I
Then-
have very good case.
When the court is indicating the mind, why are you not taking that hint?
Lordship.
If I was going to give the judgment against you, then of course, because this is not a court of facts.
Lordship. Exactly.
Why are you taking me to the facts repeatedly? Heard the matter in part. List again on Thursday. So and so date for further hearing. It part heard koi Thursday by slip koi diba. Please give the judge that simpliciter judgment
I'll say.
to the court master if possible, or on Thursday.
Right. Deeply appreciate.
Number is it? 21 now. Itu entered by December. বললো রে এটা কাঁটা দিছে না তো লাগে ঠুলো Yes.
Number 23 and 24.
Yes. Are you ready?
May I please your lordship? Lordship by senior, Mr. K. Doctor for the respondent is on legs in trial court, and also the petitioner happens to be stuck in Punjab due to flood, your
As
lordship.
prayed for by
At 2. Lordship,
not
matter
at
may
2.
be fixed at
As
2.
prayed for, list this matter again on next week or at the date did you?
Obliged.
None appears for the appellant on call. It appears that on the last occasion, I 18/7/2024, also there was no appearance on behalf of the appellant when the matter was called. Stop. In view of the consecutive non-appearance of the appellant, the appeal stands dismissed for non-prosecution.
May I please, Your Lordship? Lordship, in this matter, I was.
Where is the
sent to
counterpart, Mr. Sahaiwala?
My lord.
You were supposed to do something.
No, my lord, today was fixed for hearing, my lord.
But what about steps on for R2, R3?
My lord, that was struck off by order dated 29th of November 2023.
None appears for the appellant when the matter is called. Mr. So-and-so Sahaiwala.
M. Sahaiwala.
M. Sahaiwala, learned counsel for the respondent.
Respondent, sole respondent.
For the respondent is present. List this matter again after 2 weeks
My lord.
on a date to be fixed by the
My lord,
registry.
there is one point, my lord.
Yes.
My lord, in the IA 652, which is disposed of, this honorable court had directed the appellants to deposit 50% disabled, my lord.
All right. Anyway, they are not there right now. So then I will say after 1 week.
My lord, the date may be fixed.
All right. After 1 week, did you?
Deeply appreciated.
Take the date. Take the date. Yes.
Lordship, due to heavy rainfall, my
Why there are no representations for the appellants today? In most of the cases I have seen. Name shown. Yes.
Lordship, due to heavy rainfall, my senior is not unable to come. So,
None
Lordship,
appears for the appellant when the matter is called. Who is the senior?
S. and Krishna.
List this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
In this case, due to my personal DPI, I could not prepare the brief money. So maybe extended for 2 years to 2 weeks maybe.
Have you deposited the permanent alimony of?
Yes, against alimony we have come. They decreased the granted on the ground of
No, there was some interim stay.
interim stage.
My lord, a short date may be given. There is a stay, my lord.
Your name?
My lord, K. Sharma.
A or
K,
K.
K.
Mr. K. Sharma, learned counsel for the appellant seeks 1 week.
Not 2 weeks, my lord.
No. 1 week time for 1 week time in the matter. Stop. Prayer is not opposed. List this matter after 1 week on a date to be fixed by the registry.
Interim may be extended in the IOM.
Interim.
No, my lord. Last occasion, my lord, interim was not extended, my lord.
Interim was granted till today.
Yes,
It may be
next.
extended till next day.
Obliged.
There was some adjournment.
Yes, Lordship, I have sought consent from the opposite party.
No, when it is called, even if there is no consent, this court will give you. But when you make a mention at 10:30, do you know why you need to take their consent or not? What is the reason for taking consent? See, if you do not inform them and you mention at 10:30, the concerned advocate will end up sitting in this court
Yes,
expecting that his matter will be called.
yes, Lordship. Yes.
That is the reason you need to take consent.
I'll make sure, Lordship. Thank you. Much obliged.
Your name?
Divyansh Rathi.
As prayed for by Mr. D.
D.
Rathi.
Rathi.
D. Rathi. Learned counsel for the respondent number or the sole respondent with consent from the other side.
Lordship, any short date may be provided and matter is covered.
As prayed for discernment, with consent from the other side, seeks list the matter on such and such date.
Much obliged.
Item 34.
Yes. Any problem today?
The problem is not so serious. Last occasion, the order was passed to furnish the copy. Perhaps in a
Not given to you. You have not got it.
Lordship, I
Translated evidence of DW1.
Lordship. If it is Lordship in
Yes,
file
there is an order.
available, perhaps available in the record mirror. That can be.
It appears that though this court by
Lordship,
order,
Lordship may hear it, my lord, I can.
where you let us give you and I can have this Thursday or Tuesday.
Lordship.
Tuesday.
Tuesday.
Yes.
It appears that though this court by order dated 1/8/2024 directed the registry to provide copies of the translated evidence of DW1
Lordship.
to both the counsels appearing for the respective parties, comma. However, it appears that the same has not been provided to Mr. M. Mohanta, learned counsel for the respondent. Stop. Let registry furnish the copy of the said translated evidence of DW1 to Mr. M. Mohanta. List again on such and such date.
27
এইটো কৈ দি দিব আছে যে এতিয়া আৰু এটা সহি লৈ ল'ব
More paisa. Take it okay. Move this.
Yes.
Obliged.
Pending item number 4.
Yes, Mr. Smith.
This is an appeal under section 82 of the Employee State Insurance Corporation Act.
Yes.
Against the order and judgment dated, my lord.
Nobody is appearing for the respondent.
My lord, nobody is appearing. I think we have taken that. Even the previous date, when the one opportunity was given for the respondents to appear, but they have not appeared. I think we have also done that.
All right. Yes. We can proceed with the
My
hearing.
lord,
Yes.
my lord, this is an appeal against the order dated
10, 12,
This is a section 30 appeal.
No, madam, this is appeal under section 82 of the Employee State Insurance Act.
82.
82, madam.
এই এখন লাগিব দেই ৰূপক Yes, Mr. Smith. Section 82.
No, section 82, madam.
Yes, yes.
This is an order against the judgment of the Employee State Insurance Court.
So substantial question of law has to be there.
Law has to be there, madam. And it's an order against the Employee State Insurance Courts, which the respondents have filed under section 75 of the Act. Madam. Same if you lodge in the section 75. Madam. Well, it's regarding the dispute between the Employee State Insurance Corporations and the principal employer. Madam.
Who are you?
Well, I'm the corporation, madam. I'm the appellant, madam. In section 75, madam.
Yes. Matters to be
75G,
decided.
madam. Matters
Yes.
to be decided by Employees Insurance Court, madam. G, madam, there is relevant.
Yes.
Any other matter which is in dispute between the principal employer and the corporation, or between a principal employer and an immediate employer, or between a person and a corporation, or between an employee and a principal or immediate employer, or in respect of any contribution or benefit, or any other dues payable or recoverable under this Act, or any other matters required to be which may be decided by the Employees Insurance Court under this Act. So it's regarding to the dispute between the principal employer or between the immediate employees or between the corporation.
Here in this case.
In this case, Malad, the dispute was between the principal employer and the corporation, Malad.
Principal employer is who?
Principal employer was the respondents, Malad. Here they have been aggrieved by the order of the corporation in giving notice that which they are required to pay under ESIC.
They've been aggrieved by the notice or under?
The action of the corporation for incorporating the establishment under the ESIC Act, Malad. For incorporating the corporation under the ESIC.
Sorry, I didn't get it. For
incorporating.
Incorporating.
My lord, before bringing the establishment of the respondents
under the
purview of the ESIC Act.
ESI Act.
Before that, the lordship may have a look
Yes,
at the
Mr.
ESIC.
Smith, we have, I think, is this the last matter? The last matter on the board. Arvas. But there is sufficient time. You can go slowly.
The lordship may come at 1 o'clock also if the lordship is there.
Go for it, 1 or 2. What was the dispute? The incorporation under the ESI Act.
According to
that is the grievance.
Yes, Malad. The grievance is that according to the respondents, the establishment comes within the seasonal factory, and that seasonal factory cannot be incorporated into the ESIC Act, Malad. But only one question remains: whether the establishment of the respondents is a seasonal factory or not. That
now,
is the only
what
issue,
is the
Malad.
substantial question that has been framed?
Substantial question of law that the seasonal factory, Malad.
Where do I get it?
If your lordship may peruse the section 19A.
No. In this
issues, Malad.
Yes, where is it? This court must have formulated?
Yes.
14/6/2012 order.
My lord.
That is the order, right?
That is the order, my lord. And the grounds, my lord, here, my lord.
No, we'll go to the grounds, Mr. Speed, but since this is...
But it's an old matter, I don't know whether the subsequent question of law was...
Yes, framed.
It's framed, my lord.
Yes, order dated 14/6/12.
My lord.
The appeal is admitted to be heard on the following substantial questions of law.
My lord.
You are not aware of it.
My lord, that I may not.
Whether the finding of the ESI court that the respondent is a seasonal factory is correct in view of section 219A. The court also having recorded a finding that the factory of the respondent remained engaged in production for about 9 months of the year. Whether the finding that the factory of the respondent did not have more than 9 employees within the meaning of section 29 of the ESI Act.
My lord. That is
So, you have a look at this question.
My lord, I'm aware then, my lord, regarding this subsequent question.
Matila Nikirupa. All right, I'll come back after break. Yes. Mr. Smith.
Before going to the facts, my lordship may perhaps some of the sections which may be relevant to this.
Yes, please.
And I'll straight away go to the preamble. Your lordship is aware of the ESIC Act, my lord.
Yes.
It's for the benefit of the workers and
Beneficial legislation.
My lord, social legislation, my lord. But I'm straight away go to the preamble, my lord. An act to provide for certain benefits to employees in case of sickness, maternity, and employment injury, and to make provision for certain other matters in relation thereto. Whereas it is expedient to provide for certain benefits to employees in case of sickness, maternity, and employment injury, and to make provisions for certain other matters in relation thereto, it is hereby enacted. Section 1, my lord, this act may be called employees. It extends to the whole of India. The 3, it shall come into force on such date or dates as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of the act, for different states, or for different parts thereof. Now, section 4, there are claiming exemptions here, my lord. It shall apply in the first instance to all factories, including factories belonging to the government, other than seasonal factories.
So it
That's
doesn't
here.
the act is not applicable to seasonal
That act
factories.
is not applicable to seasonal factory. I mean, that is the whole issue here, madam. Whether the establishment, the factory of the respondents is a seasonal factory or not. But if your lordship is straight away come to section 212 of the act, madam. In which factories are brought under the purview of the ASI Act, madam.
Yes, please.
Section 2, subclause 12, madam.
Subclause?
At page 8, madam, at the same.
Yes.
Yes, madam. Factory means any premises, including the presence thereof, wherein 10 or more persons are employed or were employed on any day of the preceding 12 months, and in any part of which a manufacturing process is being carried out on, or is ordinarily so carried out, but doesn't include the mine subject to the operation of the Mines Act, and so on. So here our case is that this establishment comes under 212, whereas the case of the respondent was that it is exempted under section 112.
According to you, it is covered by ESI.
Yeah, yes, it is covered by
According
ESI,
to you.
according to me, according to the corporation, Manoj, and according to the respondent, that is the whole campaign. It does not cover because it's a seasonal factory, according to the respondents.
Is seasonal factory defined?
Yes, Manoj. Seasonal factory definition, Manoj, section 19, subclause A, page 10, Manoj.
Yes, I've got it.
Yes, Manoj. Seasonal factory means a factory which is exclusively engaged in one or more of the following manufacturing process, namely cotton dyeing, cotton or jute pressing, decortication of groundnuts, the manufacture of coffee, indigo, lac, rubber, sugar, including gur or tea or any manufacturing process which
this factory is manufacturing what?
tea. It's engaged in tea in the manufacturing. That has been discussed in the judgment also. I'm
so
here.
tea is given.
But it's given. I'm here on the period. Here, which is incidental to or connected to with any of the aforesaid processes, and includes a factory which is engaged for a period not exceeding 7 months in a year. I'm on here, mother. Engaged for a period not exceeding 7 months in a year, in any process of blending, packing, or repacking of tea or coffee, in such or B, mother.
Mr. Smith, read it again.
I'll read it from the
seasonal factory means.
I'll read it again, Malad. Seasonal factory means a factory which is exclusively engaged in one or more of the following manufacturing processes, namely cotton dyeing, cotton or jute pressing, decortication of groundnuts.
You can avoid that.
Malad.
Read seasonal factory means a factory which is exclusively engaged in
one or more of the
following manufacturing process, namely tea.
Tea. It comes under the tea, Malad.
So that is there. And includes a factory,
my lord,
which is engaged for a period of not exceeding 7 months.
7 months in a year. That's what, Malad. If it is engaged in any of the manufacturing areas, but it must not exceed the operation of the period must not exceed beyond 7 months, Malad. That is the statutory definition of this act, Malad.
And would mean,
Malad.
And would mean that one or more of these manufacturing factories,
my lord, also
should not engage for a period not exceeding 7 months.
Not exceeding 7 months. It can be covered in the seasonal factory, but it must not be engaged more than 7 months. That is the definition. Or
is there any authority on this where it says this both the condition has to exist together?
Well, no, or it's or section B,
Because my understanding, I may be wrong,
Well, no, it's-
because what I'm thinking is that what section 19A defines seasonal factory,
Well.
it means either a factory which manufactures
So and so.
1 or 2, 3, 4, which
Oh.
is in from that list.
Well.
Okay,
Well.
this is one,
Well.
and also a factory
Well.
which involves manufacturing something which is not exceeding 7 months in a year.
Well,
So if it's a 6 months,
or here, and it's not, it's written or, Malad. Malad here,
and includes
includes.
a factory which is engaged. Because you
Means
see,
it-
initially it says means a factory,
Malad.
means a factory, which factory? Which is manufacturing one of the following.
Malad.
And includes a factory
Malad.
which is engaged for a period not exceeding 7 months. So this months in a
again, here,
year
Malad,
in
this,
any presses of so and so, so and so, so and so.
Again,
So
when
that factory may
Malad.
not be manufacturing one of those listed items,
Malad.
but it could be a factory where that factory is only processing for say 4 months
Malad.
or 5 months.
Malad. That will be included in the
That will
seasonal
be
factory.
included.
Or other
Notwithstanding whatever they are manufacturing.
whatever they are manufacturing, the list, Malad, gur
Yes,
or
yes.
groundnut.
This is how I am understanding.
Yes,
I may be
Malad.
wrong.
Yes. And also, Malad, section B, subclause B also provides in any other manufacturing process as a
Yes.
central government
So
by
apart
notification.
from these two,
Malad.
any other also.
Malad. That will come under the purview of the seasonal factor within the meaning of this act, not exceeding
So
7
it
months.
is just not confined to tea and that list alone.
Not confined to
Not,
tea and all.
not that alone.
Not alone.
And it doesn't mean that tea, even if it is a tea industry,
Malad.
it has to be less than 7 months.
Less than 7 months. The operation of the factory, Malad. That is the my understanding, Malad. That's why we are here, Malad. And Malad, coming now, Malad, as a lordship got it, Malad. And one, Malad, sure, Malad, once the any establishment that comes under the purview of the ESIC Act, it will be deemed to be covered under the ESIC Act, irrespective of the number that falls between which is the required number. Malad, for establishment to be covered, minimum has to be 10. Suppose the establishment is covered today, 10. Suppose after 3 months, my workers come down below 10, say 7. But still, it will be governed by the ESIC Act under Section 1(6), Malad. That is also important. Malad. Section 1, subclause 6. Section 1, subclause 6, Malad.
Yes.
As a lordship got it. A factory or an establishment to which this act applies shall continue to be governed by this act, notwithstanding that the number of persons employed therein at any time falls below the limit prescribed by or under this act, or the manufacturing process therein ceases to be carried on with the aid of power. So, here interpretation that even if the number of the workers falls below the prescribed limit, it will be deemed to be governed by the ESIC Act, unless an exemption is been sought by the establishment under Section
Even
87.
if less than 6.
Less than 10, Malad.
Sorry, less than 10.
10. And the minimum required is 10, Malad, to come under
Even then, the ESI will be
applicable. Unless the establishment seeks for exemption under Section 87, then it will be excluded from the ESIC Act. Section 87, Malad. May not go through it today.
Section
87, Malad. Exemption, Malad.
It's all right. You take me through the provisions.
Malad. If
Because
then
it's a learning.
Yes, Malad.
Yes, 87 exemption.
Section 87 exemption, Malad. Exemption of a factory or establishment or class of factories establishment, Malad. I'll read Section 88.
Yes, please.
88, Malad. The appropriate government may, by notification in the official gazette and subject to such conditions as it may deem fit to impose, exempt any persons or class of persons employed in any factory or establishment or class of factories or establishment to which the Act applies from the operation of the Act.
So even in a case, even if the ESI Act is applicable, it can be exempted.
It can be exempted. And again, Section 89, Malad. Corporation to make representation, Malad. No exemption shall be granted or renewed under Section 87 or Section 88 unless a reasonable opportunity has been given to the corporation, that is the appellant corporation, to make any representation it
This
may
is
wish.
in case of exemption.
In case of exemption. Suppose,
But if it is automatically exempted under the Act,
Malad.
then you don't need an exemption.
If it is automatically, if the establishment of the respondents comes within this Section 1(4), then the exemption doesn't apply.
Correct.
But here I'm placing the argument because the establishment was already bought under the ESIC Act. They have been also paying the regular dues, which was required by the principal employment. So
I'm not sure of the facts, so we will
Malad,
go to the
that's
facts.
Malad, I'll come to that, Malad. So if it is exempt like section 1(4), if the covers under section seasonal factory, then it is automatically exempted. The exemption need not be taken under section 87. Whereas it is a different case in this case.
Otherwise, you will have to be given a notice.
My lord, the corporation and the state government has to provide a notification.
Understood.
My lord. My lord, if your lordship may come to the judgment now, my lord. It starts from page 5, my lord, of the appeal.
Yes. Mr. Das, you have a matter? Who's appearing in that matter at the side? He was also here. When he is together, I don't think we will have time for this court. This matter is likely to take some time. So in case
sometime also, my lordship is quick to understand.
You can have a word with Mr. Dubey if you want another date to inform. Yes.
The judgment starts page 5, my lord.
Page 5?
Page 5, my lord. Here, I'll read out the brief text of the facts, my lord, page 6 of the appeal, of my appeal, my lord.
1 second. Page.
It starts from page 5, my lord.
Yeah.
For my own.
You are reading from page 6?
Page 6, my lord.
All right.
Yeah, my lord, the first paragraph.
Yes, please.
Yes, Lord. The petitioner is a firm duly constituted under the law, having its factory at so and so. Said factory is a board leaf tea manufacturing factory. The factory is not only a small. That is in the case of the petitioner, my lord. The factory is not only a small scale.
Who is the petitioner?
My lord, the petitioner is the respondents in the
Associated Tea Industry.
Associated Tea Industry.
They are the principal.
They are the principal employer, my lord.
Principal employer. And
they have approached the ESI.
You are the Employee State Insurance Corporation.
But they have approached the Employee State Corporation Court, my lord, which functions as a civil court, just like in other property. Alternative dispute, my lord. Here, my lord, the case of the petitioner.
This is done under what section?
My lord, section. They have filed the petition under section 75 of
75.
75G. That it will include if there is any dispute regarding the corporation or any other person.
That which you had, I think,
yes, my lord, in the beginning. So, my lord, in this honorable court also, in many other cases, and referred such disputed facts to the EI court, my lord. I'll not refer to those cases, which is not relevant. Right. I'll just read out for my facts of the case a little bit. Here again, my lord, page 6. The petitioner is a firm duly constituted under the law, having its factory at so and so. The said factory is bought leaf factory, BLF, tea manufacturing factory. The factory is not only a small-scale industry, but also a seasonal factory within the meaning of 212, 219A of the ESI Act, engaged in the manufacture of tea, and Section 1(4) of the ESI Act, has excluded such seasonal factories from its purview. The petitioner never engaged more than 10 employees in his factory at any point of time, though as per the relevant provision of law, the petitioner ought not to have covered under the ESI Act. Due to some misconceptions of law, it was so covered, and the petitioner also paid some contribution as demanded. I'll leave it here, my lord. In my case, my lord, that whether it's a misconception, the petitioner, once it was bought under the purview of the Act, my lord, the petitioner has paid the contributions regarding for the employers. So it is deemed that it is covered under the ESI Act. Now, my lord, the issues at page 7, my lord, the same which involves, my lord, here also, no? Page 7, my lord, the last paragraph.
Can I just continue reading this?
My lord.
Mr. Dubey, I think I'll take some time in this matter. So in case you want another date, you both give a date.
Tomorrow, my lord.
Tomorrow, not possible. You give it to the court master. Next week or date is a date. Yes.
My lord. Lordship asked me to read this.
Just continue reading. The OP was not authorized. That same paragraph, page 6.
Yes, ma'am. Though as per the relevant provision of the law.
Mr. Saikia, you are waiting for some matter.
Item number 18. Passova for time being. Matters Passova for time being because we could not.
But now I think it will take some time. I'm in the middle of a hearing. If you want another date, you can have it. Yes, Mr. Smith.
I'll read it again, my lord. the petitioner, my lord, I'm reading in between.
Yes, yes.
The petitioner never engaged more than 10 employees in his factory at any point of time. Though as per the relevant provision of law, the petitioner ought not to have been covered under the ESI Act.
This is the case of the
This
petitioner.
is the case of the petitioner.
The petitioner is saying
petitioner's
that
case.
the petitioner did not have more than 10.
My lord, petitioner case is that the assumption could not have been come under the ESI Act. And that, my lord, here, my lord, what I'm reading is, my lord, the petitioner themselves have admitted having paid their contributions for his employees.
According to them, by misconception.
That is a misconception. Mother, that if they were aggrieved, they would have ought to come before the EI court before paying the ESI contribution. Suppose they have paid, in my written statement, they have already paid the contribution from May 2003 to September 2003. So in my written statement, I have also admitted, which is there in the judgment.
So the issues were framed whether the petitioner's factory is a seasonal factory.
My lord, whether the
it
petitioner had
more
more than 9, meaning.
Whether
petition. Once the first issue comes in my favor, the all other goes. That's why that now
Yes.
coming to the judgment, the observation of the court regarding the seasonal factory.
Yes. Page?
At page 9, my lord. But I will not go through all the judgment, the observation of the court. Page 9, my lord. Last paragraph, my lord. Here, my lord, that is the court's observation. Thus to be covered by category B, seasonal factory mentioned above, a factory in question must not be engaged in the process mentioned therein for a period exceeding 7 months in a year, while to come under the purview of category A, seasonal factory mentioned above, no such time limit is there, then only a factory can be termed as a seasonal factory. That is a court's findings, my lord. That must not be engaged in the process mentioned for a period exceeding 7 months. Now, my lord, after going through the trial, my lord, through the evidence, my lord, it is also come to the observation of the court that the establishment of the respondents, the operation continues to be operated for more than 7 months, which I'll show your lordship at page. Madam, your lordship may come to page 12, my lord, of the judgment, my lord.
So as per evidence, it is more than 7 months.
As per the evidence and all findings of the court, it is 9.5 months, my lord.
No, but Mr. Smith, this is admittedly a tea industry.
Well, it's a tea, they engage in manufacturing of tea, Malad. It has been observed by the court. And Malad, it's also been observed.
I'm not sure if I fully agree with this,
Malad.
that both the conditions has to be satisfied together. That it has to be a tea industry. Second, not more than 7 years.
Not more than 7 months, Malad.
Together,
Malad.
I have a doubt as regards
in
that,
fact, in
because
that case,
my
Malad,
understanding is
Malad.
that these are two separate conditions.
Malad.
One, it can be a tea
Manufacturing.
industry. B, any industry which does not operate
Malad,
more than 10.
I got your
And
lordship.
the third is central government can.
That is different. That
so
is
there
not
are
the case.
3 different categories
My lord.
under the Act itself.
My lord.
That apart, the ESI has been given powers to exempt.
My lord. But in that case,
You see,
Malad,
because the object is to give exemptions more, it appears.
Malad, in case of small scale industries,
Maybe.
like a small scale industries,
Because it appears like that.
Malad, that is Malad,
But here it has been taken as if thus to be covered by category B, seasonal factory mentioned above the factory in question must not be engaged in the process mentioned therein for a period exceeding 7 months.
My lord.
So they have taken it together,
Malad, they've taken it together.
right? The trial
Yes.
court.
Yes.
And
But
anyway,
the trial
let's-
court has not taken it. That has gone against me, against the corporation. Malad.
Sorry?
Trial court, the decision of the trial court has gone against me. But it is taken together. Malad.
correct. By
My lord.
taking it together,
My
it
lord.
has gone against you.
My lord, my lord.
Because admittedly, it's a team.
But it's a tea engaged in tea manufacturing or so and so.
But here, because it has been shown that it is more than 7 months.
My lord, it is in my case will be that it is the operation carries on more than 7 months.
Therefore,
so
it
it doesn't
is.
come under the
So you want it to be
not the seasonal factory.
interpreted as together.
My lord, that's my
That would be in your interest.
My lord, my lord.
Otherwise, admittedly, it's a tea industry.
No, that I'm not denying. The
Correct.
industry.
So according to you, the correct interpretation that tea industry, provided
My lord.
it
Provided-
does not operate more than 7
More than
months.
7 months.
This is
This is
how you interpret
My lord.
section 2K, right?
Yes, 2K is for the factory sector, I guess. Section 19A.
19A.
19A, my lord.
All right, go ahead, Mr. Smith.
My lord. And here the observation, my lord. And
Which this
Mana,
observation
Mana,
is from Apex Court decision.
my lord, here, my lord, I'll rely on the decision, my lord, rendered by the court itself, my lord, for your lordship understanding. At page 10, my lord. Here also, my lord.
Yes, please.
At the last paragraph, in so-and-so case, my lord, in Karnataka High Court, my lord, it's just been rendered.
Yes.
In view of the settled principle of interpretation, the import of the amendment in the present case is clear and beyond doubt. The legislative intent is clearly in favor of widening the definition of seasonal factory. Insofar as in relation to a factory exclusively engaged in the manufacturing of coffee is concerned, even the original definition of the expression seasonal factory, but within its ambit, a factory exclusively engaged in the manufacture of the coffee and engaged in the process of blending, packing, or repacking of coffee as incidental to or connected to with the manufacture of coffee, even though such factory may work throughout the year, throughout the year. In addition to the factory which was engaged in blending, packing, or repacking of coffee, not as incidental to or connected with, but with independently of the manufacturing of coffee, is brought within the statutory rubric of a.
Exactly, this is what I am saying.
My lord. Here, my seasonal factory. Here,
Yes, but this is
provided
what
a such factory work.
independently. You missed that word independently.
My lord.
This Karnataka High Court judgment says, let us read it together.
My lord.
Insofar and in relation to a factory exclusively engaged in the manufacture of coffee.
My
Now,
lord.
coffee is an exempted item in that list.
My lord, coffee.
Is concerned.
My lord.
Even the original definition of the expression seasonal factory
My lord.
brought within its ambit
My
a
lord.
factory exclusively engaged in the manufacture of coffee and engaged in the process of so and so, so and so, so and so.
My lord.
Sure. In addition to a factory which was engaged in so and so, or
Repacking.
connected with, but independently of the manufacture of coffee, is also brought within the statutory definition of season, provided such factory work for a period not exceeding 7 months in a year.
My lord. That is my understanding, man, that it's been very together, my lord. I may be wrong, my lord, but I'll come into the findings of the court, my lord, regarding the
All right, keeping the above discussion, go ahead.
My lord, at page 12, my lord. Well, and the last paragraph, my lord. However, on examining the constant exhibits, it becomes clear that the petitioner's factory remains engaged in production from the last part of the March to the last part of the December, that is,
For about 9 months.
9.5 months, my lord. That has been admitted by the court, my lord. And here, my lord, in page 13, it goes, the definition.
The evidence are there.
My lord, I think the lower court records are there.
Lower
It's
court
since it's
records
an
are-
old matter, I don't recall the purview. I'm reading it from the.
OPW1 supposed to evidence. Exhibits.
If I may read the section 19A again for understanding, my lord. Section 19A, my lord.
Yes, please.
Again, my lord, your lordship is correct, my lord. Or T or any manufacturing process which is incidental to or connected with any of the aforesaid process and inclusive factory. My lord, that and inclusive factory, my lord, in my all limited understanding, my lord.
Section 19, no?
19A, again. That is the whole interpretation of the statute, my lord. 19A, my lord. Which is engaged for period.
One second. 19. Section 19
Section 19A, man. Again, man, the same
of the
interpretation.
ESI Act.
The same definition of the seasonal factory, man.
Yes.
Okay, man, again, man, I'll come to.
Yes.
I'll come from the end part, man. There where the
an inclusive factory which is engaged for a period not exceeding 7 months in a year, in the bracket surplus A, malad, in a process of blending, packing or repacking of tea or coffee. Malad, there it comes here, malad, repacking or tea or coffee. The factories are establishment comes within A, but here it has to also be read with the not the time limit, malad, not exceeding 7 months. Malad. 7 months in a year. That it has to be operational within the period of 4 months, 3 months, not beyond 7 months. Malad. And the court, after going to the evidence and all the records, it has been observed that it has been 9.5 months. So it is its own finding that this establishment of the respondents, the operation of the factory of the respondents has been running for more than 9.5 months. So in my humble submission, the establishment doesn't come under the seasonal factory and it's not exempted under the BSI sector. That is my whole case, in the appeal. Nothing, that is a section that needs to be interpreted. And the other section, where the petitioner employs is beyond 9, that is the case of the petitioner. But here, the observation of the court, the lordship may come, has been found
The
that
substantial question is only as regards the seasonal factor. Right?
if it comes in favor of me, that the other also goes. The other section, that the employees of the petitioner is less than 9, which is also not true. The observation of the court, it has been found.
So that is so. Therefore, these because as this case, this court is now have to answer the substantial question that is formulated. Correct. So the question is whether the finding of the ESI court that respondent is a seasonal factory is correct in view of section 219A. The court also having recorded a finding that the factory of the respondent remained engaged in production for about 9 months of the year. That is taken to be correct. Now, this is purely a legal question. The facts is already admitted.
That is a statute which defines. It has to be,
one reading of section 19A indicates that a factory which is engaged for a period not exceeding 7 months in any process of blending, packing or repacking of tea will be exempted.
Provided it doesn't exceed beyond 7
Correct,
months.
correct.
That is
I read that first. So in your case, it is beyond 5.
Beyond 7 months.
So this provision then will not apply.
Not apply.
Exemption is there.
Exemption there. If they are, and once the other part of the argument is that it has already come under the purview of the
Rupak. A decision to read your Parvani. Mr. Smith, do you have the Karnataka decision?
No, I'm reading it. This is an old matter. It was
1997 LAB pre-amendment, what was there?
Earlier it was 20 as far as my knowledge goes. Before 2010 the minimum requirement was 20 workers. Now it has come to 10
That's it. I read that. 1992 LABIC 58. Okay. No, hit my leg. 58 to discontinue. Last order. Oh, already. Amar enuka arekhon book ase niki? Mr. Patwari, since you are the only person in the gallery, let us have advantage of your presence also. Have a look. Subsection 19A of section 2. The definition of seasonal factory. It was all academic discussion.
Just for a moment, leaving apart this item, if the lordship comes to the second point, whether the more employees were engaged, I'll just point out the only this.
Yes, what is there in that?
At page 14, of my appeal. 14,
Page 14.
Section 2, subclause 19A.
One second, Mr. Smith. 1992 LAB IC 58. Opposite. 1977 LAB IC 770. Regional Director ESIC versus Island Coffee Works of EN Saldana. That Karnataka High Court's case might be of some
My lord.
relevance. Anyway,
If your lordship will give me, I'll read out. And later on, I'll try to find out the Supreme Court judges regarding this.
we will, no, not to worry. Let us first finish.
The facts and that
Yes.
that first issue, substance question, your lordship has got it. Suppose it goes in my favor, it comes to the second issue, whether the petitioner engaged was the workers were more than 9. In that case also, the court's finding at page 14,
It starts from 13.
it starts from 13, issue.
Let's read from 13.
Issue number 2, adducing evidence of the petitioner, PW1 says that 6 staff employees works in the petitioner's factory. He proves exhibit 32 to 35 as the attendance register and exhibit so and so as verification signature of ESI inspector so and so. He, however, admits that 8 to 10 casual laborers also works in the petitioner's factory on daily basis. Thus, according to him, the total number of workers, employees of the petitioner's factory, both regular and casual, is 14 to 16. That is more than 9. Supporting the claim made in the WS, PW1 further states that the petitioner's factory never had more than 10 employees. Though thus he contradicts his own earlier claim regarding the total number of employees of petitioner, his said claims also shows that the petitioner had more than 9 employees. If your lordship may come to page 14 on the last paragraph.
Yes.
On perusal of the exhibit I.
6. Exhibit H or I?
That is I, if I'm not wrong.
Okay. Yes.
It is seen that that indeed total number of 20 to 25% workers worked in the petitioner's factory in different months of that period. He says that thus doing all this inspection of the petitioner's factory was found to have employed more than 10 employees. On the next page, from the above discussions of the evidence on record, it is found that the petitioner's factory had always, including on the date of inspection by the SSL, more than 9 number of employees. More than 9 number of employees. Of course, some of these were casual and temporary workers. Now, he has been admitted that the workers of the established respondent's factory is more than 9. That is more than 10. And on the last issue, which has not been raised, whether the petition was maintainable for non-joinder of necessary parties. Here, what the Supreme Court says, relying on decision that even for the purpose of filing petition under Section 75, one of the workers of the establishment has to be included in the petition, because the act has been enacted for the benefit of the workers. If the lordship may kindly, I have only one.
One second. Let us finish this, Mr. Smith, first. This recording of the evidence indicates it is seen that indeed total number of 20 to 25 employees worked in the petitioner's factory at different months of that period.
So, it is more to be 9, according to the respondent.
Then, from the above discussion, please read that. Next page, from the above discussion.
From the above discussion of the evidence on record, it is found that the petitioner's factory had always, including on the date of inspection.
This is the finding of the court.
This is finding
so
of
the
the
court has found it is more than 9.
But my issue remains.
But then, why at the end? The court came to the finding that from the above discussion, it is found and held that the petitioner's factory did not have more than 9.
And that's what the contradiction, That's what I've also said it in my ground, that contradiction.
No, because the first finding is in your support.
My lord, that's
if
what
it is more than 9.
My lord, the regulators which I've been trying to find that one side they said it's more than 9.
Then why did the court said on what basis? What is the reason for the court thereafter changing the finding?
Here, then I'll read out the however, here.
Yes, please.
However, the decision in respect to the issue number 1 shows that the practitioner's factory is a seasonal factory. Section 140 exempts such factory from the application of the Act. Hence, not only the casual temporary workers, but also the other regular employees of the petitioners cannot be termed as employees within the meaning of Section 29.
This
is the observation of the court.
This is first part. Seasonal, not seasonal. Then
And there, from the above discussion, it is found and held that the petitioner's factory did not have.
From where?
But that's where, madam, it's not been justified, madam. From where it has been said. Because the issue goes against me because of the earlier issue that the petition, the establishment comes within the seasonal factory.
No. Even if it, Mr. Smith, are you following what I'm asking?
Madam, I'm asking.
Because that is one issue.
Madam.
Seasonal, not seasonal. Independent of that,
Madam.
the next exemption is if you have less than 9, correct?
Yes, madam.
Now here, admittedly, the court came to a finding that
Yes,
you
ma'am.
have more than 9. Then how suddenly the court
That's all.
says
Hence
from
the madam appeal, my lord. That's the contradiction is there in their own findings, my lord. One
So-
side they have said it's more than 9. The other side they say not more than 9 without giving any findings, my lord. Here the finding is only that in the court's judgment,
contrary to the finding,
my lord, contrary to the findings.
isn't it?
That's that will be my submission, my lord. If it's not-
Now you can that, but now
my first issue is I have to cross the obstacle first, my lord.
yes, of course, but be that as it may, I have to decide both the substantial question of law. One is as regards
So seasonal factory.
seasonal,
Whether it is concerned,
vis-a-vis the finding of the court
my lord.
on evidence that
That.
um,
And also, my lord,
what was that finding? That finding
then
that
the more than 9 again that
no,
less.
that 9 months. However, on examining, yes, the concern that the factory remains engaged in production
My lord.
for about 9 months.
For 9.5 months. For about 9. That has been more than 9, my lord.
And here, and the second issue also, when the act says more than less than 9, the finding is more than 9
More than 9.
employees.
And on the one hand, it says more than 9, and on the other side, it says less than 9 without the proper justification. And there also involves a third issue, my lord.
Third issue is not a substantial question of law.
Malad, that was left out, Malai. I may.
But if I am, if this court is with you with the first two substantial question of law, then
Malad, then I leave it up to Lordship, Malad.
because you don't even have an opponent right now.
Malad, it was they were duly served, Malad.
Mr. Bhattacharya, did you read? Yes. What is your interpretation on section 19A? What are the conditions required to be a seasonal factory?
There are two conditions, two categories provided. First category are those, my lord, which are exclusively engaged in one or more of the following.
One of those I listed.
And includes a factory which is engaged for a period not exceeding 7 months in A and B category.
So therefore, there are two situations. Now, however, in the case in hand, the second condition, if we take that as an independent condition, there also the T comes in. It says, which is engaged for a period not exceeding 7 months in a year in any process of blending, packing or repacking of tea or coffee. Here, this is a tea factory. So, therefore, the second part, the blending, packing, repacking tea is also it's a factory.
It's a factory.
Correct?
Yeah.
Now, what he has to show is that it is more than, if it is more than 7 months, then it is not seasonal. It has to be less than 7 months. Correct?
That is my.
Correct?
Correct. If it is doing the business
Correct.
in packing or repacking.
So in the case in hand, it appears from evidence that it is engaged in more than 9 months. Despite that, the court have said it's a seasonal factory. But the problem is that it appears that the court, while exercising powers under the appeal, is exercising the powers of a second appeal because a substantial question has to be framed. 82, right?
My lord, section 82.
An appeal shall lie to the High Court from an order of Employees Insurance Court if it involves a substantial question of law. So therefore, first I have to
My lord.
give a finding whether these two questions that have been formulated are substantial questions or not. And then I have to see whether the decision is, that the parameters of second appeal has to be kept in mind.
My lord.
Yes, thank you.
That is my summation, my lord, for the whole case, my lord. In the interpretation of the section 19A, my lord. your lordship,
You are carrying any authority
no,
on?
I'm the standing counsel, my lord. Standing counsel for the corporation, my lord.
You are carrying any authority of any court as regards the powers under Section 80, the appellate powers? Any authority, any decision are you carrying?
My lord, regarding such decisions, my lord, no, my lord.
You পালে নেকি ৰূপক? মাৰ্চৱাইক মাতকচোন। মাৰ্চৱাইক মাতকচোন। So here it appears that the court have drawn wrong inferences of the proved facts,
My lord.
isn't it?
My lord. I would say wrong interpretation of the also act, my lord. In my own humble submission, my lord. Wrong interpretation of the act, my lord.
No, that's right. The courts have drawn wrong inferences from proved facts by applying the law erroneously.
My lord.
This is the situation.
My lord, this is the situation.
It appears.
My lord.
Now, suppose I interfere with the decision.
My lord.
I can just simply set it aside, or I'll have to send it back.
My lord,
That is why I'm asking the ambit of that section. Itu kune disla?
it's a caution.
Yes.
No, here only question is setting back, my lord, it will be infectious. My lord, the period has gone, my lord. My lord, if the lordship decides that this establishment of the respondents come under the purview of the ESI Act, my lord, and we have to draw a fresh assessment of the contributions, my lord. And under section 45A, we cannot assess more than 5 years, my lord, beyond 5 years. So that period has already gone, my lord. The period which the pending litigation was. Again, the fresh notices has to be served to the establishment to come under to pay the required contribution. If a lordship may for a moment also come to section 45A, my lord, there where it's all the dispute starts, my lord.
45A.
Determination of contribution.
Yes.
Determination of contribution in certain cases, my lord.
Yes.
Wherein in respect of a factory or establishment, no returns, particular registers or records are submitted, furnished or maintained in accordance with the provision of section 44 or any other official of the corporation referred to in the subsection 2 of section 45 is prevented in any manner by the principal or the immediate employer or any other person in exercising his functions or discharging his duty under section 45, the corporation may, on the basis of the information available to it, by order determine the amount of contribution payable in respect of the employees of that factory or establishment, my lord. But here, my lord, provided that no such order shall be passed by the corporation unless the principal or the immediate employer or the persons in charge of the factory or establishment has been given a reasonable opportunity of being heard. Again, my lord, provided further that no such order shall be passed in the corporation in respect of the period beyond 5 years from the date on which the contribution shall become paid.
So that 5 years is over.
5 years. I can only assess the contribution from 5 years, my lord, not beyond that. That is my submission before this court. And if I may also express one more issue that regarding a non-joinder of necessary party, my lord. Here,
1 second.
My lord.
Mr. Smith, find out
My lord.
the parameters of Section 82 of the Act,
My lord.
because when it says it involves a substantial question, generally
My lord.
you feel that the spirit of CPC Order 42 also will come in,
My lord.
because 41,
My lord.
which is applicable to first appeal. Now, because I'm concerned right now, suppose for instance, if I held both the substantial questions of law in your favor,
My lord.
thereafter what is to be done? Because under the code,
My lord.
it has to be remanded back. If I reverse the findings of the trial
My
court,
lord. So that is a good
that
question.
is one.
My lord.
Or I may send it for retrial.
My lord.
Or even if you say that there is a non-joinder, then I may say you add the parties and you do and determine. These are the courses
My lord.
which are available under the court,
My lord.
correct?
My lord.
But 82,
My lord.
suppose this is not strictly there.
My lord.
Then in 82, once I find that the substantial questions
My lord.
is there and thereafter I adjudicate that in your favor,
My lord.
then nothing remains.
Well, nothing remains. Because, my lord, if your lordship decided it goes in favor of
Prima facie, I'm in your favor,
My lord.
because the finding of the fact is absolutely clear.
My lord.
Can you please find out from the LCR those two particular exhibits? One where it says more than 9 months, that evidence.
My lord.
Second, that exhibit I, which
My lord.
says
My lord.
more than 9 people.
My lord.
Can you please have a look? Just assist. Because those are the admitted facts.
My lord, those are the admitted facts.
So just have a look and just show me. Oh. Did you?
exhibits are also marked as numbered.
They both are there.
Numbered, I cannot find the exhibit.
It's not found it. Should be there. এটা আহিলে নেকি লাইব্ৰেৰীৰ পৰা? হা? I think it is Exhibit 31.
Most probably.
Have you got Exhibit 31? Is the daily stock register. Do you have it? There is a verification report on examining.
Exhibit 31.
Yes. Run for about 9.5 months. You see, on examining the concerned exhibits, it is seen that the petitioner's factories runs for about 9.5 months of the year. Did you get that?
It's not like that, but it is an observation. Yes,
No, but that is must be there because that is the evidence.
Why not?
Is it there or not?
Exhibit 31 is there.
Yes, it is there, right? Put a flag bhalke mari diyo. And then you come to the other one.
Exhibit I, mother.
That is Exhibit I. Yes, have a look. Where are the pleadings, Mr. Smith?
Mother?
Pleadings? There must be a plaint.
Mother, it must be here, mother.
It is not part of the appeal memo, right?
Mother, not.
Please indicate that also.
If I may write down the.
Because I want to make an attempt right away. I'm thinking of dictating the judgment.
I cannot find my corporate identity.
Have a look. It will be there. It's quite a voluminous records. Take your time, no worries. All right. We'll start. This is item number Kimanasilitu. Heard Mr. M. Smith, Learned Counsel for the appellate. Stop. Though record shows that notice upon the sole respondent was served on 19/11/2016, comma, there has been no representation on behalf of the sole respondent. Stop. Pertinent that by order dated 25/7/2024, comma, this court, by way of a last opportunity, listed the matter for hearing today by giving the sole respondent a last opportunity to appear and contest the appeal. If reframe that sentence, the first part by last opportunity will go away. I have changed it. Okay, we'll just reframe it. Stop. Today, when the matter is called for hearing, comma, there is no representation on behalf of the sole respondent. Stop. As such, the matter is taken up. As such, the appeal is taken up for hearing. Stop. This appeal is presented under Section 82 of the Employee State Insurance Act 1948 against the judgment and order dated 10/12/2009 passed by the Learned Employees Insurance Court of Upper Assam, Dibrugarh in ESI case number 1 of 2007. Stop. Is the plaint or anything there?
Like the petition, yes.
Take your seat, Mr. Smith. Just be alert in case there is anything. You can let me know. A blue tunic. The relevant facts of the case are as follows. The petitioner company is a company. The petitioner company is a
firm duty constitute according to the
you say that the petitioner is
a firm according to
a tea manufacturer. The petitioner is a tea manufacturer. Petitioner has a tea manufacturing factory. The Employees State Insurance Act 1948. No, don't say all that. You write, what did you say? First, what did you say? So you say like this. Petitioner is a firm duly constituted under the law having its factory at Tinsukia. Stop. The said factory is a bought leaf factory within bracket BLF tea manufacturing factory. The factory is not only a small scale industry but also a seasonal factory within the meaning of section 212/2 within bracket 19-A of the Employees State Insurance Act 1948, hereinafter referred as the ESI Act. Engaged in manufacture of tea, and section 1(4) of the ESI Act has excluded such seasonal factories from its purview. Stop. It is the specific case of the petitioner, of the petitioner stroke of the respondent stroke petitioner that they have never engaged more than 10 employees in its factory at any point of time. However, the ESI authorities, by misconception of law, applied the ESI Act to the petitioner's firm. Correct?
No.
Stop. It further appears that thereafter the petitioner paid some contributions as demanded and later on filed an $75, right?
Yes, petition under section 75.
Filed a petition under section 75,
clause G of
clause G of the ESI Act 1948 before the ESI.
Employees Insurance Code. Madam.
It is called ESI?
Employees Insurance Code. Madam.
Before the ESI, before the
Employees State Insurance Code. Madam.
Before the ESI court.
My lord.
Before the ESI court?
Yes, madam. Yes, sir.
Stop.
ESI Code Dibrugarh. Madam.
Dibrugarh. The appellant stroke opposite party, after receiving notice, entered appearance and contested the said case by filing written statement. After taking evidence and hearing the parties, the ESI court by the impugned judgment and order rendered judgment on 10/12/2009. Stop. Aggrieved
Lordship may put the ESI case number.
In ESI case number 1 of 2007.
ESI case where you have said has filed, being ESI case number
Number
1 of 2007. I'll put this later. In the middle, you'll have to put. The ESI court framed the following issues for determination. Page 7 of the judgment. 1, 2, 3, 4. After this, we'll say evidence that. Put that before the evidence. Thereafter, evidence were laid by both parties, and after completion of hearing, the ESI court rendered its judgment on such and such date. It's already there. Okay. Rendered its judgment on such and such date, comma, whereby the application filed by the respondent stroke petitioner was allowed and the coverage of the petitioner's factory, respondent stroke petitioner's factory under the ESI Act was held to be illegal, arbitrary and void ab initio and to be not tenable in law. Aggrieved by the aforesaid judgment of the ESI court dated 10/12/2009, the present appeal was preferred under section 82 of the said ESI Act. Stop. This court, while admitting the present appeal on 14/6/2012, formulated the following substantial questions of law. 1, 2. This you will find in this pink and flag, which I have marked as A, in the order dated 14/6/12. Mr. Smith, learned counsel for the appellant, submits that both the substantial question of law formulated by this court on 14/6/2012 are question of substance and has a direct bearing in the matter. Stop. He further submits that as regards the substantial question of law number 1, the ESI court entered an erroneous observation contrary to its own finding as regards engagement, as regards the functioning and production of the subject factory for about 9 months of the year. He accordingly submits that the decision of the ESI court as regards the application of the ESI Act to the factory of the petitioner has been interfered erroneously and by interpreting the law contrary to what is stated therein, contrary to the proved facts of the case. Stop. As regards the he further submits that the substantial question of law as regards the employment of more than 9 employees by the petitioner firm is totally contrary to the proved facts, and therefore the finding of the ESI court to the same effect is totally perverse and erroneous. Stop. I have given my prudent consideration to the arguments made by the learned counsel for the appellant and perused the materials available in the case record of the ESI court, as well as the grounds stated in the appeal memo and the impugned judgment and order dated 10/12/2009. Stop. Also peruse the citation relied by the learned counsel for the appellant. Under Section 82 of the ESI Act 1948, an appeal shall lie to the High Court from an order of the ESI court only if it involves a substantial question of law. Stop. To be substantial within courts, a question of law must be debatable, not previously settled by law of the land or a binding precedent, and must have a material bearing on the decision of the case, if answered either way, insofar as the rights of the parties before it are concerned. Stop. In the present case, the two questions framed has a bearing on the decision of the case, answers to the questions affects the substantial rights of the parties to the petition Stop. Therefore, the two questions framed are substantial question of law. I shall now decide the substantial question of law number 1 as whether the finding of the ESI court that the respondent is a seasonal factory is correct in view of section 2 within bracket 19A, comma, the court also having recorded a finding that the factory of the respondent remained engaged in production for about 9 months of the year. Which is the other one? You have exhibit I. And what about that exhibit 31?
31 the yellow, orange flag.
No, the orange is one. Is there another one?
The account, it's a long one.
Certified that this register contains 97 pages. Pertinent to refer to subsection 19A of section 2, which defines seasonal factory at the outset before entering to the merit of the issue, merit of the question. Stop. Section 19A within quote, quote unquote, page 10 of the Bare Act is reproduced here under for ready reference. Reading of the aforesaid definition appears that insofar as and in relation to a factory exclusively engaged in the manufacture of tea is concerned, comma, the same is brought within the ambit of the expression within quote seasonal factory if engaged in the process of blending, packing or repacking No, delete that. Brought within its ambit a factory exclusively engaged in manufacture of tea or any manufacturing process which is incidental to or connected with any of the aforesaid processes. Stop. In addition, comma, a factory which is engaged in, within quotes, blending, packing or repacking, within close the quotes, of tea, though not as incidental to or connected with, but independently of the, within quotes, manufacture of coffee, is also brought within the statutory rubric of a seasonal factory, provided such factory worked for a period not exceeding 7 months in a year. Stop. Is it be correct?
Yes, ma'am.
That interpretation?
Yes, madam.
Stop. Stop. Thus, in order to qualify, thus, in order for a factory manufacturing tea to qualify as a seasonal factory, will have to first satisfy that it is involved in the process of blending, packing or repacking of tea, and secondly, such process, secondly, it is not engaged for a period not exceeding 7 months in a year. Right? Stop. Keeping the aforesaid definition in mind, comma, let me now examine the evidence on the basis of which the ESI court has set aside the applicability of ESI Act to the petitioner's factory. Stop. Which, in other words, is the basic question to answer as regards while adjudicating the substantial question of law number 1. Stop. It appears, next paragraph, it appears from the evidence of PW1, witness of the petitioner, witness of the respondent stroke petitioner, that the respondent stroke petitioner is a bought tea leaves factory, and it deals in the business of buying raw tea leaves and manufacturing tea leaves. And for manufacturing tea leaves, it runs for 8 to 8.5 months of the year. In this connection, it appears that the contention of the respondent petitioner is that the same is a seasonal factory. In order to prove the aforesaid, various documents such as the partnership deed, SSI certificate issued by the DIC, T-board registration certificate, renewal certificate issued by T-board, etc. were exhibited in evidence. Stop. That apart, agreement executed between the petitioner and the electricity supply department, daily stock registrar, etc. were also exhibited. Stop. It appears from the documents exhibited that especially by referring to Exhibit 20 to Exhibit 30, which are letters written by the petitioner to the Central Excise Department, where under information as regards the dates on which the petitioner's factory commences and closes its commercial production during a particular year is provided. Stop. It further appears from the Exhibit 31, which is the daily stock register, that the petitioner's factory runs for about 9.5 months of the year. Stop. Stop. It further appears that during cross-examination, the respondent petitioner, the PW1, sorry, the PW1 clarifies that the production in the petitioner's factory starts in the month of March and continues till the 1st or 2nd of December, and that the period between December to March is maintenance period. From March to December, it will be how many months? March to December?
Here, 9.5 months.
March to December?
9.5 months.
If you count from March to December?
No, yes.
About
9 months,
9.
it will be 9 months.
Stop, huh? It further appears from the evidence of the appellant stroke opposite party, witness number 1, namely Chandradhar Kolita, ESI inspector, that it is evident from the inspection of the petitioner's factory made during 4 years that every year manufacture in the petitioner factory remains stopped due to non-supply of raw leaves, but maintenance and repairing works continues during that period also. It further appears that from the said evidence that during the said period also trading and sale of tea leaves continues at the petitioner's factory and stop. What is the non-joinder argument that we are making?
Since for filing, for this purpose of filing the petition under section 75, the workers, if one is aggrieved worker or any association leader has to be included in the petition, since the legislation is for the social legislation.
Mr. Smith, coming back to the meaning of seasonal factory,
My lord.
the first part deals exclusively manufacturing tea.
Manufacturing.
So if one is exclusively manufacturing tea, one becomes a seasonal factory.
My lord.
Is one interpretation.
One interpretation. And here,
And in that, you don't need to show
my lord.
that you have more than,
My lord,
but
I
you
told
have less than 7,
My lord.
you are engaged in less
Employee
than
doesn't discount.
Yes.
But since
I'm talking about first question.
my lord. No. Yes.
Right.
Yes.
If admitting here there is a 9.5 months you are functioning, all right, you don't come under B because all the evidence shows that you are an exclusive manufacturer of tea.
My lord.
There is nothing that you have brought on record to show
My lord.
that they are dealing with some other thing.
My lord. My
Because if they would have been dealing with tea as well as say cement,
My lord. Cement, only the listed items.
then
My lord.
B, then second part would have come.
My lord.
In that, it would have to be shown that any includes 7 months.
My lord.
There is some, I think, it's not very clear because everything depends on this interpretation.
My lord.
See, the trial court, the ESI court has said, in view of the above discussion, it is found that though the petitioner's factory is not a seasonal factory covered by category B,
My lord.
mentioned above,
My lord.
it definitely
Comes under A.
Covered by category A mentioned above.
Even if assumably if it's also coming under A, my lord, it has to be read with the, my lord, the time limit, my lord. That it is involved in any process of blending. It has been admitted that it has been involved in the process of blending, packing, or repacking of tea. Provided, my lord, here, my lord, such must not be engaged more than 7 months, my lord. Yeah, I'm on that, my lord. Admitted that they are involved in those activities, but it should not exceed more than 7 months in a year. Whereas in the court has also found that the portion is beyond 7 months and 9.5 months. This is admitted by the court. So there's a contradiction to its own finding, my lord. That's my humble submission.
I'm sorry. I will have to reject your submission as far as this part is concerned.
My lord.
Because of the or. My interpretation of seasonal factory definition would mean two things.
Right.
One, you are exclusively producing manufacturing tea.
Right.
The moment you satisfy that, you are a seasonal factory and you are exempted.
My lord.
Second is, along with you are manufacturing or any manufacturing process
My lord.
which is incidental to or connected with any of the aforesaid process.
Aforesaid process.
That means with tea,
With tea.
with manufacturing of
My
tea.
lord.
You are manufacturing something else
My lord.
also,
My lord.
but which has an incidental
My lord.
connection with the manufacturing of tea. And you are not engaged for a period not exceeding 7 months.
My lord.
In a year,
In a year.
in any process of blending, packing, repacking of tea.
My lord.
So for, you understand,
My lord.
there are two, one exclusive
My lord.
and one along with tea, you are doing something manufacturing something which is incidental.
My lord.
Suppose, what could be incidental to tea? You are manufacturing the packets.
My lord. Manufacturing package or any other things.
Any other thing which
My
is incidental or connected with any of the aforesaid process. Which are the aforesaid process? Which is exclusively engaged in one or more of the following manufacturing processes, namely cotton, so and so, so and so, so and so, or tea. Correct?
My lord.
Along with that, if you're doing something incidental,
My lord.
then when it comes to tea,
My lord.
7 months
My lord.
because of that A.
My lord.
Are you following what I'm saying?
Following, my lord.
This is how I am interpreting A. Now, if I say so,
My lord.
then the substantial question is correct,
My lord.
because notwithstanding that you are that the petitioner is engaged, the petitioner respondent is engaged for 9.5 months,
My lord.
because it is manufacturing tea exclusively.
My lord.
By that definition itself, it is a seasonal factory, and therefore it will be exempted under that one. Under 4, right? It shall apply in the first instance to all factories other than seasonal
Seasonal
factories.
factory.
Now, if question number 1 is answered
My lord.
against you,
My lord.
then as regards 6, that is an alternative.
Which one is 6?
6, a factory or an establishment to which this act applies shall continue to be
Yes,
governed
my
by this act, notwithstanding that number of persons employed therein any time falls below the limit specified or under this act or manufactured persons. Because the second
lord.
question is regarding that, right?
My lord.
So even if you have, you did not have more than 9 employees,
My lord.
it will not be of any consequence because you are already a seasonal factory,
My lord.
isn't it?
My lord.
Are you following what I'm
I'm
saying?
following, my lord, but as
Am I making sense to you
my
or
lord,
not?
yes, my lord, but my submission will be dead, my lord. This has
Yes,
to be
of course
read.
I'm going to deal with your
My lord.
submission.
This is my submission will be dead, my lord, that it has to be read in all, my lord.
No,
Because
or
it has
is
been
there.
or
Second
or
part is
T.
in 2 parts.
or any other manufacturing process. But
Yes.
it has been combining as far as limited understanding goes, my lord.
No, Mr. Smith,
My lord.
or any manufacturer, not, it doesn't say or any other.
My lord.
It says the word or
T.
Or T, after that you say
Or
or.
any or.
So this or has separated it. Number 1 is the part before or.
My lord.
That is exclusive manufacturing of tea. This is one process.
My lord.
Have you understood?
My lord, yes,
The or has made it alternative. Or any manufacturing process
which is
which is
incidental to.
incidental to or connected with any of the aforesaid processes
My lord.
and includes. So here you have to include this also.
My lord.
So along with tea, if you are manufacturing something else,
My lord.
then in as far as the tea blending, packaging, refining of tea is concerned, 7 months. This has to be read together. This is not in your case. You are exclusive
My lord.
as per the evidence.
My lord.
I can stop here
My lord.
and you can ponder and we can continue on Thursday, remaining part of the judgment.
I'll go on to that interpretation of the seasonal factory.
Have a look at it.
My lord.
Because it will have some bearing.
Well, actually, it will also set a precedent, my lord.
Absolutely, absolutely. That is why I don't want to go wrong.
My lord,
Because
yes, my lord.
you see that word or.
That has to be interpreted, my lord.
So it is in 2 parts.
Yes.
According prima facie, it appears to be in 2 parts.
My lord.
1, exclusive manufacturing of tea.
Tea.
2, incidental or connected to tea, and less than 7 months in any process of blending, packing, or repacking of teas.
That interpretation has to be understood. Now I'll go through.
Here,
it.
admittedly, it's running for 9.5 months.
That is.
So if it comes in the second part, it cannot be said to be a seasonal.
Seasonal factory.
But here, because the evidence indicates that you are exclusive, one is the subject factory is an exclusive manufacturer of tea. Followed.
Yes, engaged in manufacturing process of tea. So that fact cannot be disputed.
That fact this court can't now go into it.
Yes.
It's already admitted.
So that interpretation with it, I'll go through.
And the second, you say whether the finding that the factory of the restaurant did not have more than 9 employees.
Once this case, this first incident is more important. Once
that
this
is more
case
important.
Decided, everything will fall into place.
Yes. If this court holds this against you, then second has no relevance.
No relevance.
Isn't it?
Yes, ma'am.
All right. Third part, list again on he to case kulina diya hul. Aru eta je judgment. Kitya? Thursday ni. A2 Thursday due.
No, it can be since my lordship has already heard, only that part interpretation has to be done. It won't take much time for lordship.
All right, we'll make an attempt on Thursday.
My lord.
Okay.
All right.
Otherwise, I will forget.
My lord.
If I
Yes.
put it to next week,
My
because
lord.
we are
Yes, my lord.
a long weekend is coming.
My lord. But this observation has already been recorded, my lord.
Yes, this has already been. Whatever has been recorded will remain here.
But now
I
the
will,
main
in
part
fact,
comes, my lord.
now the main part comes.
That's why it will
So, because the entire thing will depend on the
My
interpretation
lord.
this court gives to 19.
19. Well, actually, that will set a precedent for all the cases, my lord.
You also have, I think, this Karnataka High Court's decision. My office has got it.
No, I'll go
So,
through some more cases.
Anyway, it will photocopy DD. You have a look at this two
I'll
also,
have-
and you go through.
My lord.
One that, and second the power under 82, that appellate power.
My lord.
If I come to a finding in your favor, thereafter what is to be done?
But there, in this case, my lord,
Because you see, you are aware of the same powers of the appellate court,
My
right?
lord.
Once the appellate court reverses the finding,
My lord.
the appellate court will do what?
Only in my all respect to submission, it can only set aside, my lord. It will be deemed to
It's
be.
all right, but I have taken that you have already shown that 5 years and all that.
My lord.
But let us be clear.
My lord, it's
The
absolutely.
scope and ambit of the powers.
Yes,
It will be important.
Yes, my lord.
All
It's
right.
a long pending matter, my lord.
Yes. No, I want to finish it. So that's why Thursday.
My lord.
The if I do better. Yes. Right.